Okay. Same, huh? Eto. A das, huh? A das একে ধৰণৰ লিখিব order dated so and so passed in WPC 2542 of 2025. Order dated on 17/9/2025. Our representation dated. What is the date of your representation, Mr. Das?
My lord, presentation
No date.
copy 22/9/2025.
Where do you get the date?
Page 13, my lord.
13. Where is the date?
22.
22/9/2025. Huh? Okay. Issue notice. You take steps by speed post with AD. Okay. By 2 days. 2 working days.
Representation. Street post.
No, you have issued notice. You take steps by speed post with AD. And returnable date is 27 July.
Obliged, my lord.
May it please your lordship.
Yes,
Kindly
Mr.
peruse the order dated 8/6/2026.
Yes, we have seen that.
Lordship.
Mr. Sharma?
Yes, next, please, there.
Hmm?
I have brought the record, lordship. That lordship, there is the last order. We have a clause, lordship. That in the clause number 23, lordship. They cannot claim any remission on the basis of any enforcement. They are doing the settlement as is value basis. That part is being also. I'm just expecting. It's being also upheld by the coordinate bench also held that they cannot claim it, and division bench also. So.
Where is the notice inviting tender? You have it.
Yes.
What does it say? Because this quote on 8/6 had made certain observations. You take time to don't Monday we'll have. You should come prepared with the records. When did you get the records? When did you get the records?
Morning, lordship.
Okay, then Monday we'll have it. Okay. Pursuant to the order dated 8/6/2026, comma,
Yeah, two also, lordship. I can. Two, I have some problem to do, lordship. Monday, lordship.
Monday.
Lordship.
Monday. The record, comma, the records have been received by the Learned Standing Council for stuff. He, however, prays for some time to enable him to go through the same para. In view of the above, matter is adjourned to be listed on Monday date to DDP, huh? Monday will be 22nd.
Lordship.
22nd.
Oblige, lordship.
You come prepared on Monday.
You could not locate the agreement.
You flag mark the relevant pages.
Sorry, lordship. I'm sorry.
Yes,
Let's
Mr.
see.
Sarda.
My lord, actually, my lord, what happened? Earlier, my lord, against the advertisement of the, my lord, that work without terminating my contract, I approached this honorable court, my lord. Simply what I was passed, but then, my lord, on the basis of the agreement that it should be in Delhi, my lord, this honorable court took a view, my lord.
Arbitration.
No, read petition, my lord.
Okay.
But read petition cannot be, my lord, 226 to it very clear, my lord, that read petition. Anyway, my lord, we have approached the High Court, High Court of Delhi, and the High Court of Delhi, my lord, you have also see, my lord, that
Your agreement was terminated.
subsequently terminated, my lord.
That was the cause of action in the writ petition.
Subsequently, my lord. Yes.
Now, what is the cause of action? How did it?
Termination. Termination was stayed because advertisement was issued prior to termination.
No, we have not understood the fact.
No,
What had happened?
Advertisement, my lord,
There-
same work was, fresh advertisement was given.
No. Tell us the background facts. You were allotted on work
Yes,
in pursuant to an NIT.
my lord. We were working, my lord. While working, my lord,
It was cancelled.
Before cancellation, my lord, they advertise the same again, my lord, for tender, issue a tender. NIT.
How come you're working?
That is the, my lord, no, then, my lord, in the meantime, my lord, subsequently they have cancelled, terminated.
Another NIT floated, and thereafter your work was cancelled.
Yes. My lord.
Work with petitioner cancelled. Then what
Then,
happened?
my lord, we approached the no court interim order passed, but subsequently, my lord, on the basis of the contract, my lord, that the head office, my lord, the Delhi should be the jurisdiction.
Initially, WPC
Yes.
at Gauhati. Thereafter you were relegated to Delhi.
Delhi, my lord, you'll also find at page 132, my lord.
Yes,
132, if you'll also see. Read please, my lord.
yes.
Yes, you'll-
Thereafter,
132, my lord, page 132, my lord. We claim, my lord, the 20 crore note, my lord, regarding. After some hearing,
132 is what?
page 132, annexure 21.
And that is the order.
Yes,
Writ petition before the High Court.
before the Delhi High Court.
And
After
whether-
some hearing, it agreed that
Joint measurement.
joint measurement of work will be conducted.
Hmm.
But then joint measurement is at 133. But they found that I am entitled to 5 crore 44 lakh and odd. My lord. Joint measurement was conducted.
Admitted amount.
This is admitted. We claim
That-
more, but this is admitted.
Okay.
Now,
Now,
before the Delhi High Court, next, my lord, hearing, you will also see page 173.
hmm.
173 may be seen, my lord. Here, my lord, on the basis of joint measurement, the High Court passed the order. Value of the unpaid work was calculated as per joint measurement, so and so, so and so. Let respondent file an affidavit clearly stating as to whether said amount has been released to the prisoner or not. Let the same be filed for your own today.
Yes.
Then, my lord, it came to before different bench. A different bench said that next 174. Different bench said that the material, essential, integral cause of action has arisen
Yes.
outside the jurisdiction of this court where the contract was performed, merely because head office of the National Highway and Fisheries Development Corporation Delhi should not be the sole determinative factor to entertain the instant petition. At this stage, Learned Counsel for Prisoners seeks liberty to withdraw the instant petition with a further liberty to approach the jurisdiction High Court. Accordingly, we have filed this matter. Now we are, although we claim more, my lord, but we for the admitted amount, my lord, only 5 crore
Okay.
44 lakh.
And the contract was performed in Dhubri district.
Mr.
Contract was
uh,
performed in Dhubri, my lord. I didn't this.
That is okay. Now, Mr. Saikia, you are for whom?
Right.
NHIDCL. You are the paying authority.
Paying.
If it is a joint measurement, you have agreed to it. What is the impediment in not paying?
It was on the jurisdiction of the court. The restriction, the idea, this court has dismissed the jurisdiction also.
Now, see, we will not go on this. See, a party cannot be left remediless.
Yes.
From here, you relegate to Delhi, Delhi to Gauhati. How they cannot be made to settle?
So that's.
We are not very keen on the jurisdiction issue. The work has been performed in Dhubri. Why should they go to Delhi? We'll adjudicate here. Now, there is a joint measurement.
Joint measurement.
Leaving aside the jurisdictional issue, which you are not interested at all. Joint measurement, there is almost an admission of some amount, 5 crore or something,
This with regard to the unpaid amount.
unpaid amount. Now, what is your response to this? Have you filed your response?
No, but notice has not yet been issued.
Okay, we'll issue notice then. Okay. Heard. 3. What was the first writ petition?
My lord.
What was the first writ petition?
First petition, that was just a petition, my lord. That is, I have.
Okay, heard 3, GN Sahewala, learned senior counsel. Mr. Murarka, are you there in the record, on record? Assisted by Sri M. Sahewala for the petitioner. Para? As per the facts projected, the petitioner was allotted a work of construction of a bridge. Bridge. Road. Construction of a road at Dhubri. And while the work was being executed, there was another notice floated. Whereafter the work with the petitioner was cancelled. Full stop. though the order of cancellation was put to challenge initially in this court, there was a view that since the head office of the respondent is at Delhi, at Gauhati, this court was apprised of the clause conferring jurisdiction at Delhi, and accordingly, the writ petition was closed with a liberty to the petitioner to approach the court at Delhi. Full stop. The Honorable Delhi High Court was accordingly approached, and orders have been passed on 14/10/2025. No, on 14/10/2025. Full stop.
Yes.
2025, which had directed for a joint measurement. Full stop. It is the case of the petitioner that in such joint measurement, an amount of rupees 5.44 approximately, he is found to be entitled to, which has not been paid. No, their contention.
Yes.
It is their contention. We are not saying.
There is a
It is their contention. Is found to be entitled to,
Page
which
133.
has not been paid. Full stop. Subsequently, when the matter had come up before the Honorable Delhi High Court on 10/2/2026, the Honorable Court, on noticing that the cause of action had arisen in the state of Assam, had given liberty to the petitioner to approach the appropriate court, and the writ petition was dismissed on withdrawal. Full stop. Accordingly, the present writ petition has been instituted. Full stop. The learned senior counsel has submitted that it becomes crystal clear from the joint measurement regarding the entitlement which the
Page 133.
respondents have not
133.
released. Let notice be issued, returnable on 29th of July, 2026. Union of India Ministry, you are there. What is your name? On behalf of whom? GPGU. Okay, please get your name. For one, then HIDCL, Mr.
Yes, he.
Sri R.K. Talukdar, learned counsel assisting. Sri P.J. Saikya, learned senior counsel, accepts notice on behalf of the respondent numbers 2 and 3.
23.
Let extra copies be served upon the learned counsel for the respondents during the course of the day.
Well, by Monday, my lord.
Within 2 working days then. You come up with your instruction. We don't want to keep this kind of. Mr. Sawala, are you also challenging the offloading of the work in this writ petition, or only the amount?
No.
Only the amount.
Advocate amount. My lord, I think your lordship has not written 5.44 crores. I think crores has not been.
5.44 crores.
I think the order.
No, crores. It cannot be 5.44 rupees.
I know. Yes, I think.
You will not come for 5 rupees.
No.
Like 6, item 6.
Item 6, Mr. Stiladitya.
It's related to some wrongful deduction of certain amounts from the petitioner agency, my lord. The
We
similar,
have been passing similar orders.
yes, my lord, here, my lord, on 10th, my lord.
Yesterday also it passed an order, I think.
Yes, ma'am.
Here
That
is
is
the
slightly different because there have been series of applications in this matter, my lord. My senior friend has got orders,
the last pass, my lord, in the similar matter, my lord.
You can make the corrections, we can dispose this off.
my lord.
Okay, make the corrections. Make the corrections by pencil. Make the corrections by pencil on the factual
In the
aspect.
in order,
Yes.
in the order, my lord.
In the order, and show it to Mr. Sharma. Both of you jointly submit, will okay, dispose.
Except, my lord, one subject. Stay may not be called for because the entire amount has allegedly.
Here in the case, my lord, that more than the show cause amount has been deducted, my lord.
Subject the outcome, my lord.
There's no question of stay here then.
Yes.
You make the corrections.
Yes.
Naam likha.
Returnable date may be given.
No, you're disposing of.
My lord,
Okay,
here, my
sir.
lord, no, my lord.
You give an agreed date of inspection.
Yes, my lord, but they have to reply, my lord, because here in this case, my lord, they have to reply. Otherwise, my lord, main issue
No,
relates.
what we have stated that you will go file your reply, and after consideration of the reply, they will take appropriate steps. That is the order, final order which you have passed.
No, my lord, this is the order, my lord. I have.
What is it, Mr.
My
Sharma?
lord,
Is it slightly different, my lord?
Then we'll issue notice here.
Yes, my lord, here it issue notice, my lord, I will give the copy and I will correct it, my lord.
Different stages, different matters, madam.
Okay, we'll issue notice then.
Yes,
Okay,
madam.
okay, okay. Well, let us issue notice. Give a copy of the
Yes. Kindly.
third Sri Shiladitya Learned Counsel for the petitioner who is aggrieved by
Madam, the show cause is waiting.
by a notice dated 27/3/2025 issued by the respondent three, which whereby there is a threat of deduction from the PAD balance amount. What is PAD?
Pre-authorized debit balance, madam, that is agreed.
Pre-authorized debit balance
Pre-authorized debit.
from the PAD balance account, and has also questioned the validity and also questioned the show cause notice dated 24/2/2025 issued to it regarding such deduction. Full stop. It is submitted that similar matters have already been adjudicated by this court. Para. Let notice be issued, returnable on when? Returnable on 27th July, 2020.
27 July.
Sri M. Sharma, Learned. You are standing counsel. Standing counsel, IOC accept notice on behalf of all the respondents. Let extra copies be served upon him within 2 working days. Full stop. What kind of interim order are you suggesting?
My lord, there is no further deduction, my lord.
It has
Because
already been taken care of.
Yes, my lord, but if further there cannot be any.
Is there any threat of further deduction?
Le-
Sri Shiladitya Learned Counsel for the petitioner prays for an interim order to the effect that no further deduction be made. Para. Sri Sharma, the Learned Counsel for the respondents, has however submitted that deductions have already been made
Carried out.
and there is no aspect of any further deduction. Para. In view of the said undertaking, this court is of the opinion that no interim order is required at this stage, which may however be considered if and when the need arises.
My lord, the returnable dates can be, my lord, 7/8, 7/8, my lord. Other
7/8.
cases are fixed.
Other case, then 7/8 করে দেব।
7/8.
7/8. You serve extra copies. You can take this back.
My lord, in this direction, my, there was a direction in this order, my lord, a certain direction, but that direction should be, my lord, in the order, my lord. Otherwise, we cannot approach the authority, my lord. In directions are in last part of the order, my lord, paragraph 12, my lord.
It is however the following the previous orders passed, comma. No, don't say following. In taking into account the previous orders passed, comma, this court also issues the following direction at the interim stage. Number 1, the respondents are directed to jointly and severely to provide the scan copies / photocopies of the ERV slips
Yes, please.
from which is the basis of the show cause notice. Para. Next number. The petitioner would be given an opportunity to compare those with the originals, for which the petitioner would visit the office of the plant office
Plant office, madam.
at North Gauhati
Not one.
on which date?
Subject to my fingerprints, slides.
Oh, 6/7, then let it be the same on the
Like the
6,
same date, madam.
6/7.
Here it was 5/7. Yeah,
Then my lord will give it 8/7, madam.
8/7,
Yes.
8/7.
Voluminous.
Full stop. Number 3,
In this,
the petitioner may thereafter file the reply on or before.
Same date, my lord.
No, 8/7, how can he file?
Or 24.
On or before 21/7.
21.
Date is 21. Is it date?
Little later, my lord, because it was past 10 days earlier, my lord, because
No, 8/7, you are going to make the inspection.
Yes.
21/7, you file the reply.
Yes.
Enough, 21/7.
Yes.
Full stop. Next, the respondents would thereupon fix a date for personal appearance, fix a date for giving hearing, personal hearing to the petitioner, which has to be before the returnable date.
Returnable.
Okay. We're leaving there up to them. Returnable date, we're making 8/7/8, I think. 7/8.
My lord, in the first direction, my lord,
Hmm.
the direction was to, my lord, to supply the copies, my lord. A date may be fixed, my lord. Before that, they must supply the copies, my lord, ERBs, my lord. The
Can
first
you tell
direction-
us? First, the said copies be served to the petitioner on or before
On 26. no?
27/6, my lord, it gives us some
6. Today is what?
90.
Oh, okay, 27/6. You get a week's time. Okay. Last part is not required. The
Well,
deduction
yes,
part is
sir.
not
It
required.
is further observed that all the deduction which has been carried out till date shall be subject to outcome. of
That
this-
is okay. It is needless to mention that the deductions made would be subject to the outcome of the writ petition.
Lordship. Obliged, lordship.
Sir, we are
This is the second round of litigation, my lord. I'll show the order. My lord, here is a case where, my lord, why we came up before this court. This is, the contract is of hiring of hydraulic work unit, my lord.
Hiring of
Hydraulic work unit.
hydraulic.
Yes. Rig work actually. Now, my lord, tender was floated, we participated, and LOA issued in our favor. Now, terms and condition of the LOA, there was no final contract was not signed. LOA was that there are two bidders here. One bidder, I being Indians from the India side, because the main company in Dubai is a parent company. They have got the experience. So we took their help. Petition number 2 is the bidder. Now he participated. He LOA was issued in his favor. Now there is a clause in the tender that 9% of the total contract value. The total contract value was about 300 crores odd. Now 9% of the work that is yearly, that you have to pay a performance security. So if it is 100 crores, out of 100 crores, 10% has to be paid.
9%.
Yes,
around 9.
about 9 point something has to be paid, 9.5 has to be paid by the bidder. That is petition number 2. That is a performance guarantee, my lord. Now,
Every year.
no, once only, once.
Okay.
Now, there is also a clause in that only. Suppose there is a parent company is from Dubai, my lord. Additional performance security has to be paid also. That is 50%. Suppose I am taking the experience. So the petition number 2 is taking the experience of petition number 1. Then 50% of that amount has to be paid. That is 4.5 crores has to be paid. By the
50% of
petition number 1.
50% of which amount?
My lord, that performance security, my lord. 9.5 crores. 9.5 crores, my lord, he has to pay it. In addition to that,
Yes.
4.5 crores has to be paid by petition number 1.
Hmm.
Because we are taking the help of an experience on the count of experience. Now, my lord, we could not pay it for some other reasons, but 4.5 crores has been paid by the parent company. Right?
Petition number 2 could not pay.
No. Now,
And parent
Now-
company is petition number 1.
yes. So now
Yes.
we took the help of petition number 1. That why don't you also pay? They were ready to pay, but there were some RBI restrictions.
Hmm.
So we could not, that amount could not be paid, 9 crores. So ultimately it lead to termination of the contract.
Hmm.
LOA, termination of a contract, because the formal agreement was not signed. It is a termination because of LOA.
Hmm.
Now, my lord, we filed, my lord, a writ petition before this court. Before that, we represented the matter before the court, before the authority, Oil India. 3 grounds were taken. Termination was illegal before that. Now, they also decided to blacklist me. Third is that, my lord, my additional performance security, which was given by the parent company 4.5 crores, that should be refunded. These were 3 points which were
Those
taken.
were not acceded to by the
Now,
respondents. So you came before this
before
court.
the writ court. Now, my
Which
lord, there is an-
WPC what?
now
WPC?
WPC, my lord, order is
No, no.
yeah, WPC number 1840, my lord, 2026.
Two WPC. Two writ petitions.
No, one writ petition.
Oh, 2026.
1840 2026.
2026.
Yes.
Okay.
Now, the court said we will not adjudicate this matter because your repetition is pending. We'll give a direction to the authority to decide the repetition.
Yes.
Now, if you see, my lord, the operative portion of the order
Hmm.
that has been passed by the authority,
Now, what is your cause of action?
my cause of action means that, my lord, so far as the blacklisting, that holiday go, that has been, they have lifted that. There is no problem. There is no problem on that. But my problem is on the issue number 3, my lord, where that they have not taken any decision regarding about 4.5 crores returning of the.
Refunding of.
Yes, there is no decision. They have given a one-line decision, my lord. If you see that at 301, please see at 301.
What has been stated?
They have stated 3 lines.
Hmm.
Kindly find attached here order passed by the appellate authority against the appeal submitted by you. The appellate authority has considered your appeal partly. That is, remaining holiday period has been lifted. However, the performance security amount forfeited toward non-compliance of the contractual obligation shall not be refunded by oil. That's the only. That is why we are before this court. One is that, where is the question of a formal, there was no contract between the parties. No, the number 2, where is the question of forfeiting? You can only forfeit so far a bid security is concerned, not about the performance security, as per the terms and condition of the contract, of the tenders. So in that view of the matter, whether in pursuance to the terms and condition of the tender,
Okay.
whether
We'll
this
issue.
is what.
We'll issue notice here. See, Mr. Das has broadly, which you have understood, he has based his case on 3 main grounds. First, it is a non-speaking order. You have not cited reasons why you have withheld the performance guarantee. Number 2, he is on the route that in absence of a contract, could you have taken the step of forfeiting the performance guarantee?
Additional security.
And thirdly, he says that in absence of any clause, even in the LOA, you do not have the jurisdiction or authority
Correct.
to withhold this. Basically, 3 grounds.
Stand of the company, as far as I have been able to obtain telephonically,
Hmm.
the LOA itself is the contract, because it says the contract shall be effective from the date of the issuance of this LOA.
That will
And there has
examine.
been a performance failure on his part. And
That
therefore,
will
the
examine.
performance security has
That
been-
will examine.
That is
In
why
many of the
it was
cases, we do not. We find that a formal contract agreement is not entered into. It's on the basis of the LOA.
Yes, Lord.
But then the question would perhaps arise that whether you'll be given power to withhold performance security. It's not bid security.
Our understanding is.
Did you
that
go
the
ahead with the
performance
work?
failure on his
I
part.
am sorry.
Did you go ahead with
No,
the
no,
work?
no, we could not.
Work was not started
No,
at
no,
all.
not started. They terminated.
Because of this non-failure. Ultimately, it was a performance failure on their part. Because.
And
the
this is
LOA
not-
itself
not-
was the contract.
Yeah,
I know
that
it
can
is-
be one of your interpretation, which we may agree or may not agree.
My
Performance failure of performance, whether it will start even without starting of the work. And because not not being able to start because of non-payment of the work performance.
security, performance security.
Okay,
Another aspect, the arbitration clause is always there.
it's there
Arbitration clause is there.
in the LOA.
Yes.
LOA, there is no clause of arbitration. Sorry. There is no clause. Only when you enter into a final contract, my lord, then the
Agreement might have an arbitration clause.
Yes.
An arbitration clause will necessarily require an agreement where there is
Correct.
meeting of
Absolutely.
minds that
Yes.
we are agreeing to a arbitration
Right.
process.
Absolutely correct.
Okay.
I'll check upon that.
Okay. Heard. Sri D. Das Lalan Senior Counsel, assisted by Sri R. Sharma for the petitioners. Full stop. The grievance of the petitioners is with regard to a work for which letter of acceptance was granted. Full stop. It is the case of the petitioners that there was a requirement for depositing 9
5%.
9 crores.
No, what is the percentage?
Percentage will be 10%.
10% of
This is the LOA.
of the value
Yes. If you
as
see,
performance security.
Lordship may see pays
is
164.
163 mile,
What is it?
163 and 164
Mm.
at 4.0. 164, 4.0.
4.0%.
4.0 clause. 164,
Quote the figure he said that.
164,
Okay.
4.0.
You said percentage. That's for okay. Wait.
not 10% of the, that's why.
10% will be 10% will not be 9 crores.
Yes,
Okay. Well, let us put the figure.
9 crores.
কি করলো আগরখানি? Depositing an amount of rupees 9 crores as performance security in the form of bank guarantee. Full stop.
By the petition number
No,
2.
by the petition number, no, by the petition number 2, since full stop. There was an additional requirement. There was a further requirement for depositing additional performance guarantee
Please see 165. That is-
of being 50% of the performance security, which is to be deposited by the petition number 1, full stop. While the petition number 1 could deposit the amount as stipulated, comma, such amount could not be deposited by the petition number 2,
Yes,
leading to termination of the LOA.
yes.
Full stop. The petitioners had earlier approached this court by filing WPC 1840 of 2026, which was however disposed of by a direction to decide the representation. Full stop. In the by the impugned decision, comma, while certain aspects have been considered in favor of the petitioner, namely lifting of the remaining period of the remaining holiday period, comma, the performance guarantee deposited by the petition number 1 has been forfeited. Correct?
Yes.
Para, it is the London Senior Council has submitted that amongst others, no reasons have been cited for such forfeiture, and he has also questioned the authority and jurisdiction to withhold such performance guarantee. Full stop. He has categorically submitted that in absence of any clause empowering the respondents
Yes.
to withhold, comma, the same cannot be done as a formal contract was yet to be entered into between the parties. Para. Sri A. Sharma, Learned Standing Counsel, IOC,
Oil India Limited.
Oil India Limited, on the other hand, has submitted that in the instant case, the LOA is itself to be treated as the formal agreement.
Formal contract.
Formal agreement. Full stop. He has also justified the action taken by the respondents. Para. Be that as it may, comma, let notice be issued, returnable on when? Tell us. 27 July, is it okay? 27 July?
Yes.
27 July 2026. Sri Sharma, the Learned Standing Counsel for 1, 2, 1 to 5. Extra copies. Why have we made the RBI party?
Yeah, because there were some formalities whereby we couldn't get that
Okay.
permission.
Okay.
Yes.
Steps for service of notice upon the respondent, profound responder 6 be taken by speed post PTD. Steps within 2 working days.
Oblige you, Lordship.
Clear place.
Here, Sorry Department issued a tender in the month of August 2025.
Accordingly, petitioner submitted his tender and along with 3 others bidder. Petitioner was the highest bidder. In fact, others were the bid amount was far below the minimum revenue. So petitioner was the only high bidder and successful bidder. Accordingly, the comparative statement was prepared, but it was never no logical conclusion was.
It was not settled with you.
Not settled with it. Then we have approached this honorable court. Honorable court directed the authority to bring the tender notice into logical conclusion. In the meantime, on 30th of April 2026, we have submitted the certified copy of the order along with a representation. But on 2nd of May, they have issued a tender, again order, Lordship will find at page 37, that stating that the some bidders have objected due to abnormal enhancement of minimum revenue. And another reason was cited that there was no adequate number of bidders, only one successful bidder were there. So that is why they have issued this order, directing the authorities to initiate a fresh tender process. So being agreed, we have approached this court again.
Who were the earlier, how many bidders are there? 4 bidders.
4 bidders.
And yours was found to be the only eligible bidder.
Yes, madam.
Eligible.
Eligible in the sense, one deficiency was there, as per tender.
No, was there a technical evaluation also?
Everything was successful, only one defect was there, that we could not submit that balance sheet of 3 years because our society was a new society, It was registered in the year 2024 only.
No, that is not the reason for not
No.
giving it to you.
Yes.
No, what we are asking is whether there was a technical evaluation of the bids submitted by the parties.
Advisory committee was there, according to their
Now, to be more specific, were the bids of the other 3 bidders found to be technically responsive?
no, because they are far below the minimum revenue.
No, that is the financial aspect. We're on the technical aspect, whether they had fulfilled the requirements of all the documents.
That is not known.
See, there may be a cartel formed. You may have some of your friends to bid with defective documents. In the name, we have 4 bidders, but actually there is 1 bidder. That is why we are asking whether they were technically responsive. If they were technically responsive and they failed to compete with you in the financial bid, then probably you will have a case.
Yes.
Because it is the only objective of a tender to have the highest or the lowest bidder. Now, we want to know whether the other bidders' bids were technically were responsive, whether those were eligible. Mr. Sharma?
So in this lordship, the society is not of 3 years. So they fail to give the 3 years auditor report.
So
We cannot give lordship.
They
because-
cannot give new society.
Yes, we cannot give lordship because of the Supreme Court judgment, lordship.
Why?
Because lordship, the Supreme Court has, Honorable Supreme Court has directed that we have to stick by the 2018 notification.
Mm-hmm.
2018 notification.
What is there?
Their lordship, they have to give the total balance sheet, lordship. 3 years balance sheet.
No, that is okay, but for a new, how do you apply the Supreme Court judgment to his case?
In this case, we cannot apply. So
You
they-
cannot apply.
yes, but they are not selected in that case, lordship. So
No,
we
how do you exclude somebody with a condition which is not even applicable to them?
lordship?
You are required to have 3 years balance sheet.
Yes,
If you are in existence today,
lordship.
how do you have a 3 years
In
balance
that
sheet?
case, lordship, our understanding is that if new society which do not have 3 years experience cannot compete.
Where is the clause? You have to have a clause.
No, here, lordship, because Supreme Court has asked us to go for lordship, we may go through it. So we have issued an so
Okay, at this stage, let us issue notice. We will adjudicate this.
That is lordship.
Hearts free N.K. Kolita, learned counsel for the petitioner. Full stop. As per the facts projected, a notice inviting tender was issued in August 2025, in which the petitioner, along with 3 bidders, had participated, and the bid of the petitioner was found to be the highest. Full stop. However, no action was taken for settlement of the fishery. Full stop. The petitioner had earlier filed a writ petition where there was a direction to conclude the tender process in accordance with law. Full stop. However, wide the impugned notice it is 2/5/2026, a fresh tender has been floated for the same fishery. Full stop. Para, Sri Kolita de Lanet Council has submitted that such action is wholly unreasonable and requires interference inasmuch as the petitioner had turned out to be the highest bidder in the validly concluded tender process. Para, the aforesaid facts projected have been disputed by Sri P. Sharma, the learned standing counsel, Fisheries Department, who has also relied upon certain judgment of the Honorable Supreme Court.
An SOP issued by our department. Lordship.
Supreme Court, pursuant to which SOP has been issued by the department. Para, let notice be issued, returnable on 27th of July 2026. Sri Sharma, the learned standing counsel for 1, 2, 3, 5 and 6. No, 5 fisheries.
Not there.
5.
5 years.
Additional District Commissioner Fisheries.
Yes.
You're for 5.
Yes.
4 and 5. 4 and 5 area.
I'm 6 always.
You does. He's for 6. Extra copies. Yes, how you are proceeding with the new NIT?
Yes, Lordship.
Are you participating?
Till then, my lord, no, my lord, the tender notice has not been issued.
Okay.
So my only order has been passed to initiate the
We don't,
process.
Lordship, the NIT has to be issued by the deputy commissioner. We instructed them.
Okay. Since no fresh NIT has been issued, this court is of the view that no interim order is required to be passed at this stage. Full stop. The petitioner is, however, at liberty to approach this court if there is any new development.
Right, Your
Obliged.
Item 65, supplements.
We are going to say grievance to new NIT has been ordered has been issued to go for a fresh tender process.
May I please?
Yes, Mr. Bodri.
My lord, this case relates to the non-payment of hire charge, my lord, of the vehicle. And there is in my lord, a kind of admission, my lord, lordship will.
Kind
see-
of.
Kind, my lord, directly they did not, my lord, lordship will see.
Who has made the admission?
Is the authority, my lord, who vehicle, who requisition my vehicle,
Head of the department.
my lord, is a district magistrate, my lord, Kamruk.
A district magistrate will do head of the department. Yes, is there any admission?
Lordship will see
Mr.
for a
Talukdar?
moment, my lord, page 50.
Mr. Talukdar will say whether it's an admission or not.
Yes, my
No
lord,
admission
serial
is
number
that-
8, my lord.
It has to be by the head of the department.
The
Malad-
district magistrate will be head of the department.
My lord, it is
Is the head
written,
of the district that is fulfilled, but is it an admission? What are the wordings? Page,
Lordship kindly see page number 15, serial number 8,
page
15, 1
15.
Lordship. Serial number 8. The hire charge shall be paid to the submission of the bills in duplication of the completion of the duty of which the vehicle is hired. The bill shall be forwarded to the concerned.
Where is the admission?
Lordship. Then next page, vehicle number has been given, my lord, amount is also fixed.
No, this is the rate.
My lord, that is only.
No. This is not
That is
admission.
only admission, my lord.
This is the rate. No, this
admission
is
is
not
that,
admission.
Lord.
This is the work order.
My lord, only this much, my lord. Then I have to make an application seeking for a, my lord. I'll file additional affidavit, my lord.
You should have done additional affidavit. This is not an admission. This is the work order. You approach the civil court. Or we withdraw this, file it with admission.
Lordship, can it be like this, my lord? Some other day, my lord, I'll take instruction for withdrawal.
What will happen? Nothing is going to happen.
And if they have any kind of document, then I'll.
Heard Sri J.I. Borghi, a learned counsel for the petitioner, who has approached this court for with a claim for release of contractual bills,
No, my lord, higher charge.
contractual bills pertaining to hiring of vehicles.
My lord.
The learned counsel has drawn the attention of this court to the order dated. What is the date of this order?
Random order dated, my lord. To date asset document assessor. It is 28 August 23.
Where do you get the date?
16.
It's not the date.
Date is there, my lord.
This is as per government notification. This is not the date of the notification.
To date.
Has drawn the attention of this court.
Date there, madam. Okay. That's it. 25.
To an undated order issued by the additional district magistrate, Kamrup Metropolitan, for hiring of the vehicle for the period 1/10/2023 to 30/11/2023. Full stop.
24.
Para. 3. R. Talukdar, the learned State Council has, however, submitted that to entertain a writ petition. Various orders, there are various orders.
Month.
Orders for various periods. The Sri R. Talukdar learned State Council has, however, submitted that to entertain a writ petition with a claim of the present nature, the petitioner has to fulfill the requirements as laid down by the Honorable Full Bench in the case of Tamser Ali versus so-and-so report and so-and-so. One of such mandatory requirements is to have an acknowledgement of the liability in writing by the chief engineer / head of the department, which is admittedly not there in the instant case. Para. 3. Borbia, the learned counsel, prays for some time to obtain necessary instructions, documents, and to enclose the same, if available, and to place the same, if available, by way of additional affidavit. Para. Matter accordingly stands adjourned to be listed on 17th of July.
Obliged.
You take instructions, you withdraw it, go for a civil court.
66.
Yeah, please, your lordship. Lordship, in this case, in page number 28, my lords, tender was floated, my lords. So basically, it was a tender for supply of scientific equipments, my lords. So in this matter, my lords, so we have approached a original equipment manufacturer called Agilent, my lords, in which, my lords, we had actually had previous relationships also. My lords, so the basis of the to impugn order is that in the
You were an aspirant in the tender process.
yes, my lords.
You participated in the tender.
Participated in the tender. My lords. Thereafter, many requirements have to be fulfilled. There was one document that was called an authorization certificate. My lords, that authorization certificate was told to be fake. My lords, I'll take through some pages, my lords. So, my lords, in page number, my lords, 36. So, my lords, we had previous relationship with Agilent, my lords. Page number 36, my lords. This is an authorization certificate, my lords, in which, my lords, the Agilent would give us the authorization to participate in a bid. So this was for a different project altogether, my lords.
Yes.
So, my lords, in this case, what has happened at that point of time, my lords, if my lords comes to page number 37. So at that point of time, my lords, this authorization certificate was given us through an email communication. Now, my lords, with regards to the present tender, which is the subject matter of this writ petition, my lords, in this matter, my lords, come to page 39.
Yes.
So this is a different tender, this present tender, my lords. My lords may see, we have asked for a few things, such as the, my lords, authorization certificate, experience certificate, performance certificate, OEM turnover certificate, compliance statement certificate, quotation, so and so, my lords. But however, my lords, the only procedure
You asked for whom?
from Agilent, my lords.
Okay.
From the same supplier, my lords.
Okay.
My lords, the only procedural infirmity, or my lords, the lacuna done by in this case, my lords, all these documents that you have asked for,
almost all documents were received through online mode. The only document which is not received through online mode was this authorization certificate, my lords. So thereafter, what happens, my lords? So in page number 40, my lords, when you ask for this certificate, Agilent, the sale representative, my lord, of the notice sale representative, page number 40 has actually sent us the quotation also, giving us a go ahead that you can actually participate in this tender. However, my lords, what happened is this, that the page number 42 is the, my lords, authorization certificate, which is alleged to be a fake certificate, my lords.
42.
Yes, my lords. Now, my lords, the present contention before this court, my lords, is this, that this is the certificate which is given offline, my lords, was given offline to us. Now, my lords, as per industry standards, my lords, these certificates are sometimes given offline by the sales representative as well. My lords, in 43 and 44, we have actually annexed some certificates which we have actually got through offline mode in different bids, my lords. Now, my lords, what has happened is this, that when we participate in the bid, my lord, that we participate in a technical bid and we will told as L1. My lord, in technical bid, actually what happens is that the bid is not visible to anyone, but there were only two bidders in this. The opponent bidder actually given complaint to the, my lords, to the authorities that the authorization certificate that we had received was actually fake, my lord, which we did not know. And therefore, on page number 45, they had given us a so-called notice, my lords, that the said authorization letter, well, it reads that the said authorization letter with reference number so and so was issued by manufacturer firm Agilent Technology dated. However, on inquiry, the firm had denied issuing this letter to D2 Enterprise. Now, my lords, the question here is this, that, my lords, the authority has actually gone some and done some inquiry with regards to the fact that whether this authorization certificate was correct or not. Thereafter, my lords, we candidly give a reply because we had some procedural infirmities in page number 46, my lords, which becomes the whole aspect that this, if I may read page number 46, the reply we gave to the so-called notice, my lords. May I read it, my lords? We used to begin our expressing our...
What was the date of this? 45?
45 was, my lords, date is 3/11/2023.
Now what has happened now?
No, my lord, what has happened is this, my lords, we gave a reply. In that, my lords, in page number 46 is very important, my lords. Thereafter, I'll summarily, my lords, come to the conclusion. Now, page number 46, my lords, I just want to read this, my lords. We used to
Now,
begin
what is the cause of action now?
cause of action, yes, my lords, what happened. So basically, we gave a reply. After we gave a reply, my lords, they actually debarred us without giving a so-cause notice, which was actually, my lords, challenged before this honorable court, and the honorable court then, my lords, actually quashed that debarment notice. Thereafter, my lords, they gave us a fresh so-cause notice, and then, my lords, they gave us also a personal hearing. In that personal hearing, we have categorically stated before the authorities that, my lords, this all the aspect we have given the email communication also, my lords. We said that every aspect is got online. The only procedural infirmity that we had was this, that, my lords, we did not get the procedural certificate, the authorization certificate through, my lords, offline mode. However, my lord, in page number 58 is the impugn order.
58. Yes.
58, my lords, para number 3. Whereas in order to verify the complaint
What is the
clarification,
day? What is the date?
that is, my lord, September, that is 22/9/2025, my lords. 22 September 2025.
Yes.
So, my lord, in this case, my lord,
Depart from participation.
yes, my lords. So, in this case, my lords, they have actually proceeded on the fact that the email communication where it stated that actually we procedurally we could not obtain the authorization certificate, my lords. They gave us the maximum punishment of 3 years, my lords. However, my lords, thereafter we did an internal inquiry and found out that, my lord, there was no mala fide on the part of our, my lords.
Mr. Burman, you should know what to speak, what not to speak. You are moving this, challenging an order of which date?
My lords, 29
September 25.
25, my lords.
So you need to say that this is the order.
Yes, my lords.
Do you expect this court to pass a final order today?
No, my lords.
Or do you expect the court to have the response?
No, my lords.
So why do you wasting the court's time?
Yes, my lords. No, that's
Then you may have many points.
yes, my lords.
Put it in your, keep it in your sleeves.
Yes,
There'll be a stage to argue.
Yes, my lords.
What is the point of going to the
Absolutely.
history?
I'm grateful,
You
my
say
lords.
that otherwise also you are issuing notice.
Yes, my lords.
This you have come to the court so late.
Yes, my lords.
So there is no
No.
question of any interim order.
No, my lords. Basically, we did a, my lords, a comprehensive internal inquiry, my lords, that what happened actually.
But
There are
ultimately, what is the order of the, which order has been put to challenge?
22
September 25.
29 2025, because thereafter, my lords, we
We will issue notice.
no, my lords, thereafter what has happened, we have also filed an 64, my lords. We filed an FIR with the police station also, my lords.
Okay, then what happened?
My lords, FIR with the police station on page number 64, my lords.
Yes.
My lord, the investigation we have not followed up, but however, my lord, on the basis of that department,
FIR was lost when?
May, my lords,
Regarding what?
regarding the same, my lords, that the authorized, we were given offline certificate which were misled. My lords, thereafter, my lords, on page number 66, now on the basis of that impugn order, even other departments are moving against us and telling us that we are also debar you, my lords. Now, this is a notice from Jal Jeevan Mission, my lords. So, my lord, what has happened is this, my lords, because of this informative, my lords, even other departments are also coming and giving, my lords, notices to us to debar us from the departments, my lords.
No,
This is, my lords, a fresh notice.
That is the law of blacklisting. If you are blacklisted,
Yes, my lords.
you will not be given till the blacklisting is either the period is over or is interfered by a court.
Yes, my lord. This is, my lords, 8 June 2025, my lords. This is a fresh notice
Hmm.
given by SART department, and they have referred to this, my lords, impugn order.
Hmm.
So, my lords, this is the issue, my lords, that
So unless the impugned order is interfered with,
yes, my lords.
who are the parties here?
My lords, parties is finance department, my lords.
Okay.
Jal Jeevan is not the party because, my lord, we are asking this honorable
So
court to interfere.
we'll have to issue notice, get the response.
My lords, an
There
interim
are
order.
consequential actions
Yes, my lord.
emanating from this action, but this action, the legality we have to challenge, we have to examine.
Exactly, my lords. Exactly, my lords. I'm so grateful, my lords. But however, my lords, if my
So what
lords,
do you expect today?
my lords, stay order of the impugn order, stay of the impugn
Of
order.
September 25,
No,
you
because-
suddenly come to the court and ask for a stay.
No, my lords.
What is the law of blacklisting?
My lords,
What is the law of blacklisting?
my lords, there are two things, my lords. First of all,
Were you given notice?
we were given notice, my lords.
You are given notice, you are given a hearing. Thereafter, what remains?
My lords, two things, my lords. First of all, the representation that was given by us, my lords, that we have been actually supplied an unauthorized certificate offline, my lords. The first inquiry that
Those
they
are
did,
on merits of the case,
Yes, my lord,
Mr.
therefore-
Burman.
yes, my lords. The first
On
thing,
blacklisting, what is the law? Which case law are you referring to
my lord,
on
there are many, my
blacklisting?
lords. One is Kunjilata Industries and Kranti Industries, my lords.
What
So,
does it say?
my lord, it says two things, my lords. First of all, whether in the matter, my lords, whether they have
So without
adjudicated-
giving them a hearing, we pass a stay order.
my lords, if the
How
stay order
are
is
you
not
coming to
given,
the
it will-
court after 8 months?
No, my lords. The only reason I'm saying this is, my lords, because they could have further inquired that whether
These are all your arguments are merits.
yes, my lords.
If you are arguing on a stay order, you have to make 3 cases.
Yes, my lords.
Where is your diligence, due diligence in coming to the court in time?
My lords, we did not come on time because, my lords, we made up, my lords.
We are not on the reasons, Mr. Burman. Have you come on time or not? That is the objective satisfaction of this
My
court.
lords, we have actually, my lords, gone through, my lords, may come to page number, my lords, 60.
60.
60, my
Yes,
lords.
what is there?
My lords, after that, we have actually make a fact-finding report, my lords, of the
Fact, then you remain there. Why have you come to the court now?
no, my lords, because, my lords, other
Why have
department
you
also-
come to the court now? You remain there.
no, my lords, with all due respect, my lords, because, my
No,
lords,
you are satisfied with the fact-finding report. Go to some other authorities. We are asking a question. Have you come? Where have you come to the court?
my lords, because this department order is, my lord, bad in law, my lords, because, my lords, our representation has
That
not
bad
been
in law has to be adjudicated in a final hearing.
Yes, my lords.
Are you arguing for final hearing
No,
on the
my lords.
motion stage?
No, my lords.
Then
All that we praying before this honorable court today is, my lords, that this matter be adjudicated. Our representation.
have we said no?
No, my lords. Stay order. We are requesting for a
Stay order. You have not met the requirements of a stay order.
My prima facie case we have, my lords, because
Prima facie case. What is a prima facie case?
prima facie case.
Have
that,
you
my lords,
given notice? Answer is yes. Are we going to the merits of a blacklisting? A writ court?
No, my lords.
Then,
My lords,
if you know answer is no, then what is your case?
my
Do you
lords,
want the case to be dismissed today?
no, my lords.
If you want, we can dismiss it. We'll give a
No,
reason.
no, my lords. I'm sorry, my lords.
Heard. 3. What is your name?
Amberman, my lords.
M. Burman, Learned Counsel for the petitioner who has put to challenge an order of blacklisting dated. What is the date?
22/9/2025, my lords.
Where do you get the date?
Man, it says there's a detailed signature at page number 59, my lords.
50?
9.
22/9/2025. Full stop. It is the case of the petitioner that pursuant to a tender for supply of scientific equipments, the petitioner was found to be, the respondent authorities had moved on an allegation made by the competitive bidder that one of its certificates of authorization was fake. Full stop. The petitioner was accordingly issued a notice on 3/11/2023, which was replied to. Full stop. Thereafter,
My lords, it
The-
is not 3/11/2023, my lords.
what is the date? Page 45.
My lords, it is 8/8/2025, my lords. It is in page number 57.
No, what
Because
is
my,
for-
the earlier department notice was quashed by this honorable court, my lords.
that we are seeing?
Yes, my lords. This is my lord 57.
No, that we are seeing. 45 we are seeing now.
Well, it's 311.
3/11.
311.
3/11/2023, which was replied to, followed by an order of debarment. Full stop. The petitioner had approached this court by filing a writ petition. What was the direction earlier?
My lords, a fresh, it is in page number 53, my lords, 11. Well, it's my lords, the so-called notice was set aside and liberty was given to them to initiate a fresh notice.
Whereby, by the order dated, come on, order dated 11/6/2025 had interfered with the process with a direction to give a fresh show cause notice. Full stop. The matter culminated with an order of debarment dated September 22, September 2025, which is presently challenged. Full stop. Para. The learned counsel has submitted that such debarment has been made on certain facts which are incorrect, and there was no attempt on the part of the petitioner to submit any fake authorization letter. Full stop. Para. Let notice be issued, returnable on, yes, which date? On 24th of July 2026, Sri B. Gogoi, learned AAG, appearing on behalf AAG, Assam accepts notice on behalf of all the respondents. Let extra copies be served. Full stop. You want to ask to reject your interim order?
My lords, actually,
Now, if you are pressing, we'll reject it. If you want, you can record it. If you do not want, we'll not record it.
no, my lords. Then.
And then let us reject it. Otherwise, it will not. Again, Sri Burman, the learned counsel, prays for an interim order.
That may,
No, we are citing some reasons of para. This court interim order. He has cited that based on the said debarment order, there are subsequent action taken against them by other authorities, including the Jal
Jal Jeevan Mission, my lords.
Jeevan Mission. Para. The said prayer has, however, been objected to, opposed by Sri Gogoi, who has also submitted that the subsequent action taken by the Jal Jeevan Mission is not even the subject matter of challenge. Full stop. Para. This court has noticed that the debarment order is of September 2025, and the approach of the petitioner to this court is after almost about December, January, February, March, April, May, June, almost about 9 months. 9 months. Full stop. This court is also prima facie of the view that the debarment was preceded by an opportunity given to the petitioner. In that view, this court is
only
not
one thing may
inclined,
be written,
not
my lords.
inclined to pass any interim order at this stage,
No, only one thing
which
may
is
be-
accordingly rejected. Yes,
Only
next.
one thing may be recorded, my lords, that we have also approached the police officer, my lords, on page number 54. I'm so blessed, my lords.
Next.
Item 9.
May I please your lordship? Lordship, non-payment of admitted amount, lordship.
Order dated Lordship 11/5/2026 may kindly be seen Lordship. 11/5/2026.
Where is the acknowledgement, Mr. Doctor?
Lordship, they have filed affidavit in opposition Lordship. That
Admitted.
Lordship.
Yes, Mr. Borua?
One
My learned colleague has referenced some order 11/5/2026.
paragraph 4.
Yes, pursuant to that lordship, deputy commissioner has again validated bills and vouchers sent to the government lordship, PNRD.
Then we can close this.
Yes, definitely.
Madam Thapa, close this. Heard Sri PP Dotto, Learned Counsel for the petitioner. Also heard Sri SR Borua, Learned State Counsel, Miss P Thapa, Learned Counsel appearing on instruction of Sri S Dotto, Training Counsel PNRD, Miss MB Castro for the respond number. Assam election and Mr. Chalia, Finance Department, huh? Para? Considering the subject matter involved as well as the aspect that this writ petition is pending since the year 2019, the same is taken up for disposal at the admission stage. Full stop. Suffice it to mention that the respond number 2, that affidavits have been exchanged and there are further instructions which were made part of the records, including recent instructions dated 15 June 2026, which has been placed before this court. Para. The cause of action pertains to a claim for contractual bills for supply of
food items, food
items during the Panchayat election of 2018.
Lordship.
Full
In
stop.
respect of Dhemaji Sadar
It is
subdivision.
submitted that in respect of the Panchayat election 2018 held in Dhemaji Sadar subdivision, the petitioner had supplied food items
Lordship.
to the polling parties and the officials in terms of the orders placed. Full stop. The petitioner had accordingly submitted bills which were not paid. Full stop. In this writ petition, there is a claim for an amount of rupees 17,27,200. Correct?
Lordship.
Has any amount been paid till now?
No, 7 lakhs Lordship.
Initially, it was 24.
24 lakhs, 17.
Of which 7 lakhs we have paid, and now remaining lordship 17 lakhs.
17 lakh 27. It may be mentioned that while the total bill was about 24 lakhs,
13,000.
was 24 lakhs approximately, an amount of rupees 7 lakhs has been paid
Lordship.
to the petitioner, which is mentioned in the petition itself. Para?
No, there are 4 of our affidavit.
No, he has also mentioned.
Lordship.
Yes.
So, para. Sri Dotto, the learned counsel for the petitioner has submitted that as regards the acknowledgement of the liability, such acknowledgement has been made in the affidavit filed by the respondents. Para. Sri SR Borua, Learned State Council, has submitted that the liability is admitted and he has drawn the attention of this court to the affidavit in opposition filed by the respondent 2 dated 1/12/2020. He has also referred to the affidavit in opposition filed by the respondent 3 and 4
Lordship.
dated 6/3/2026. Para. He has placed before this court our latest communication dated 15/6/2026, whereby the concerned district commissioner Dhemaji has again placed the matter before the Panchayat and Rural Development Department to take steps for release of the outstanding. Para?
To the tune of 17 lakhs 13,200.
Hmm?
To the tune of 17 lakhs 13,200.
I have flag mark.
Oh.
Yes, Lord.
Para. The a perusal of the documents placed before this court includes a communication dated, includes a communication of the same date written to the Commissioner, Panchayat and Rural Development Department by the District Commissioner Dhemaji, whereby, so far as the petitioner is concerned, there is a mention of an amount of rupees
17 lakhs,
17 lakhs
13,000.
13,200, full stop para. In view of the aforesaid position, comma, this court is of the view that the requirements laid down in the case of Tamsir Ali so by the Honorable Full Bench stands fulfilled in as much as the admission has come in the way of an affidavit filed by the competent authority, followed by written instructions placed on record para. In view of the above, the writ petition stands allowed by directing the concerned Panchayat and Rural Development Department,
As well as finance also, Lordship.
concerned departments to concerned departments to take immediate steps for clearing the outstanding
Lordship.
as indicated above.
That's it.
First of the entire process be undertaken and completed within a period of 3 months
Lordship.
from the date of receipt of a certified copy of this order.
Lordship.
The papers placed before this court by Sri Barua, including the letters dated 15/6/2026, are made part of the records.
Of Lordship.
Item 10. This is 22/5. Okay.
Lordship, here we have challenged the award dated 28/22.
Award of what?
Lordship, of the labor court law.
Labor court.
Lordship, respondent number 2.
Other side,
Lordship, he has not appeared in spite of service of notice.
you are the management.
Yeah, I'm the manager.
The workman has not appeared.
Yes, Lordship, in spite of service of notice. Lordship. Your Lordship, basic our contention is that the respondent number 2 is not a workman. And it is admitted fact that he retired.
23 matter.
Lordship,
23 matter.
Lordship.
Service complete. We'll have the we'll appoint an amicus for the workman. Okay. We'll have somebody who does labor matters. Can we have Mr. Santanu Chakraborty?
Lordship, his name may be recorded. I will inform.
No, we'll appoint him in the court. Please,
Lordship, I will
Okay.
come with.
after a while.
Lordship.
Please, the Lordship. Lordship, the extant matter pertains to non-payment of contractual bills.
Admission is there, Mr. Hende?
If I may draw my, yes, madam. If I may draw my lord's attention to the order dated 22nd of May.
Yes,
passed By this honorable
yes.
court. There's an undertaking by the learned.
Okay,
counsel.
where, yes.
Lordship, we have already processed the payment regarding this, Lordship. Some discrepancies are there in the office of the accountant general as well as the treasury, because of which payment could not be disbursed to the petition.
When can you rectify this?
Lordship, that has to be rectified from the treasury officer, not from ours.
Yes,
That is reflected
Finance Department,
finance.
Mr. Chalia. See, some movements are there. Let it be sorted out.
But
So
it may
that-
be fixed after the vacation on a date till
No,
then.
we'll pass orders in presence so that he can take some steps. Finance is a party here.
My lord,
Names reflected or not?
respond number 6, my lord.
Names not reflected.
Not-
Mr. Chale, your name is not reflected. Finance is a party. There was an admission, there was an submission made by the Standing Council Water Resource regarding the steps taken for disbursal. Just gone one step ahead. The acknowledgement, everything is there, the steps for disbursal. And Mr. Das also said steps have been taken, but there is some anomaly which so far as the treasury officer is concerned. You look into it and. Oh, Mr. Handy, they are not parties. We make a request, Mr. Okay. Heard three, what Handy?
P handling.
B.
P.
Heard through P. Handy Learned Counsel for the petitioner who has drawn the attention of this court to the order dated 22/5/2026, full stop. In the said order, comma, the Learned Standing Council of the Water Resource Department had submitted that 15 days time be granted for disbursal of the amount of rupees 4,82,214 to the petitioner after statutory deductions. Full stop. Para. The matter was accordingly adjourned. Para. 3. R.M. Das, Learned Standing Council has, however, submitted that though steps have been taken for such disbursal, comma, there is some clarification required from the treasury officer. Full stop. Para. Do the treasury officer or the finance department is not made party in these proceedings, comma, this court requests 3 H. Alia, Learned Standing Council, Finance Department to look into the matter and take adequate steps for resolving the dispute so that the amount which has been admitted be disbursed to the petitioner in accordance with law. Para. Let the relevant papers be handed over to Sri Chaliha during the course of the day, and let this matter be listed for consideration on 27th of July.
Obliged, Your Lordship.
You have this back. Let the name of Sri H. Chaliha be reflected in the court list.
May it please Your Lordship. Your Lordship, what happened, a person has filed a private respondent has filed a complaint, Your Lordship, regarding the Majithia implementation of the Majithia Waste Board recommendation. Now, we have taken a specific objection that he is not.
Who is for R4? You are for R4.
But now, there is one thing, Your Lordship, one development has taken place during the pendency of this case. The management and the editorial has entirely changed now. So I need only one date to whether I can continue in the case, because I had appeared for the erstwhile management.
But it's not been purchased by anybody.
No, Doni Goham has been purchased, not the Asante.
Doni Kocham has been purchased. Who is the new owner? But the entity is the same. Doni Kocham
Entities,
Private Limited.
Private limited.
The owners have changed.
Owner.
Okay, you want to have some instruction whether.
That's whether I can.
Okay.
One day recommend.
Heard Sri R. Sharma, Learned Counsel for the petitioner. Also heard Sri T. R. Gogoi, Learned Counsel. Also heard Sri R. Talukdar, Learned State Counsel, comma. Madam, you are for whom? You're with, okay. For the full stop. While Sri T. R. Gogoi, Learned Counsel appears for the respond number 4. Full stop. The writ petition is with regard to the implementation of the recommendation of the Majithia Wage Board, correct?
Yes, recommend.
Full stop. Para. Sri Sharma, the Learned Counsel for the petitioner, has however informed that there is a change in the management, and therefore he would like to have the instructions regarding his continuation in the assignment. Full stop. Para. In view of the above, the matter is adjourned to be listed when? We'll have it, no urgency as such. On the reopening 13th, Mr. Gogoi, 13th, you can have instructions.
Yes.
Because next week also we can have, if you are agreeable, next week also we can have. Only for this,
Maybe after, because he will have
then on 13th.
interim to continue on it.
What kind of interim?
Your Lordship, the labor officer has passed an order in violation of section 17.
He should have.
In violation of section?
17 of the working journalist conditional service. What has happened?
Okay,
you have
interim
written-
order passed earlier to continue till the next date of listing.
Obliged.
Item 13.
May I please? My lord, this is non-payment of contractor's bill, my lord. No affidavit is filed, my lord.
Affidavit, where is the acknowledgement?
My lord, acknowledgement exactly, my lord, not there, my lord.
Acknowledgement not there, how do you
My
entertain a
lord,
writ
my
petition?
lord, I have,
The matter of 2012 and 13, quarter.
my lord, I have written, my lord, the authorities for acknowledging, for
Let it
a
not do.
certificate, my lord.
Let it not do. If you do not meet the requirements of Tamsir Ali, you are not going to entertain a
My
writ
lord,
petition.
other six similarly.
No, other, we cannot,
My
we have to follow the full bench.
My lord, this
Can you
is
say something against the full bench?
I have mentioned this, my lord, that paragraph, my lord.
That
Paragraph,
will not be enough. If there is no acknowledgement, writ court will not entertain.
paragraph 11, my lord.
What is there?
The other similarly cases are, my lord.
That can be done. Writ petition cannot be entertained. Sorry.
Let them file, my lord, affidavit.
Sorry. That is not the,
Either admitting
that
or,
cannot be approach. That is not the approach. Approach the civil court.
my lord, the other cases are same of the same year. my
How
lord.
can he say something against the full bench?
In the light of the full bench, others are disposed of, my lord.
What others?
My lord, this, my lord,
Where is the full bench? What has the full bench said? Acknowledgement by whom?
my lord, after my lord inquiry, my lord, this was disposed of, my lord, rejecting the inquiry, and then, my lord, if admitted, then it is.
To entertain a writ petition, there has to be an acknowledgement by the head of the department or chief engineer.
My lord, can you see this, my lord, orders, my lord?
These orders is by a full bench.
Not my full.
Then
bench.
why are you showing those orders?
In the light of the full
Sorry.
bench, my lord, this is.
We are not following. We'll go by the full bench. Third, your ad hoc.
K. Uddin.
K.
Uddin.
Third free K Uddin learned counsel for the petitioner, who by means of this application has made a claim for release of contractual dues. Full stop. It is submitted that 3 works were handed over to the petitioner in the district of Hailakandi and Karimganj, which were successfully executed by him. And accordingly, bills were raised amounting to rupees 2,29,367, which were not paid. Full stop. Para. The learned counsel has accordingly submitted that a direction be issued for payment of the bills, as till now no affidavit has also been filed. Para. 3. RM Das, learned standing counsel, Water Resource Department, has submitted that to entertain a writ petition, a petitioner has to fulfill the requirements laid down by the Honorable Full Bench in the case of Tamsir Ali versus so-and-so reported in so-and-so. Full stop. Amongst others, there is a requirement of an acknowledgement in writing by the chief engineer / head of the department, which is not there, which is admittedly not there in this case. Full stop. He has also raised the issue of delay in as much as the work orders are of the years 2012-13, and the approach to this court has been made in the year 2025. Para. 3. Uddin, the learned counsel, has submitted that in similar cases, orders have been passed for verification. Para. The Honorable Full Bench in the aforesaid case of Tamsir Ali has clearly laid down that to entertain a writ petition for adjudicating a claim for contractual dues, certain essential requirements are to be fulfilled, which amongst others would require an acknowledgement in writing by the chief engineer / head of the department. Full stop. For any reference, the relevant observations are extracted here in below. Para. Admittedly, there is no such acknowledgement in writing as stipulated by the Honorable Full Bench. Full stop. Therefore, without even going to the aspect of delay in approaching this court, this court is of the opinion that the present writ petition cannot be entertained. Full stop. The same is accordingly dismissed. Full stop. The petitioner would however be at liberty to approach the civil court if permissible under the law.
All right.
May I pray, your Lordship? Lordship, item number 74 is the interlocutory application which we had filed. What has happened is, Lordship, the work which
You are pressing the IA.
40 time being.
IA for what?
Lordship, we are seeking a stay of a tender which has been issued on 17. It pertains to the same work which was earlier allotted to the petitioner, subsequently terminated by the respondent
The
authority.
termination is the subject matter of challenge.
Yes, Lordship.
Yes, what do you say? What do you say? What is the work about?
The
The
work,
work is basically about maintenance of the Digboi township. This is IOCL matter. This is not per se his work because his termination was 2024. It was challenged. There was also an interim prayer that no allotment should be given. It was rejected at the point of time. Now in 2026, there is a new tender because these are of perennial nature. There is some problem in a particular house. And the township
These contracts are given for a particular duration.
given for a particular duration.
How
because
normally, what is the duration?
duration was for 2 years plus 1 year extension.
Okay.
In 2024.
Now your petition is of, your cause of action is of 24.
the original writ petition, the cause of action is 24, but the new cause of action arises on 17/6/2026.
No, that cause of action is regarding termination.
Termination of the same work which has now been put.
Now put
in the
to tender. Now,
Yes, Lordship.
now who was running the show in the interregnum?
There was no one, because
But
Lordship, we made a,
maintenance of the township, how do you prevent?
Lordship, we made a RTI application on 3/6/26
Yes.
asking whether, what is the current status, whether any tender has
You
been issued.
participate in this without prejudice to your right.
But my writ petition becomes effective.
No, no.
Lordship, may I pray for a simple
Without
answer?
prejudice to your rights.
Lordship, can order be passed that they
See, we don't
proceed
want
with
the
the
work
tender?
of maintenance to be put on hold. We are very clear.
Lordship, let them proceed with the tender. Let them not finalize it. Lordship will have the entire matter immediately after the vacation.
That
Lordship
is
will
what we are,
dispose-
that is what we are passing. We also participate without
Lordship.
prejudice to your right
Lordship,
and do not finalize.
Lordship.
So the difficulty is, this is all about maintenance.
Understood.
entire
No, we are not,
And this is a
Mr.
tender-
Sharma, we are not passing a blanket stay order. We'll be making it an observation that the entire matter will be heard on the next day.
Lordship.
So if you also could see the new NIT, it is a splittable work of 125 areas. It is not only it's not only one building construction work, entire township. It
No, and
covers
the earlier work which has been offloaded, that was also relating
work,
to the same.
Same work.
same, but there are different zones. It was not only one tenderer. There are multiple tenderers who had participated.
No, he was given the job of the entire
particular zones. It was
Which zone?
zone wise.
which zone?
Total 120 zones were there.
No,
Out of
the
which
earlier tender process was for which zone?
Lordship will see page 161 for a minute, Lordship,
Yes.
of the writ petition.
When
Lordship,
are you contemplating to have the last date?
It is on 7/7
last date of the new tender.
7/7/2026.
I am ready
7/7.
for argument of this case on any date, maybe next Tuesday also.
No, no, 7/7, you go ahead. We'll have this fixed on 16th of July.
Lordship.
Mr. Sharma,
17th of July. is-
no, 16th of July, Thursday. Thursday, final hearing.
Lordship.
Okay,
Tenders are opening
7.
on 9/7,
you go ahead.
on 9/7.
9/7, do not finalize.
One
16th.
aspect of this matter, what is his case? His case is of termination. It was a contract that is a determinable contract. Now, he had produced certain documents which were not valid documents, and we had this termination clause wherein if a party doesn't submit the valid documents, it can be terminated. So the
No,
contract was
Mr.
terminated.
Sharma, we are not asking you to not to go ahead. You go
Because
ahead.
the
You cannot,
difficulty is-
before 16th, are you in a position to give the work?
No loss, but lordship knows sometimes because of the business of this court also, matters get adjourned. The difficulty would be 125 zones.
We
And
will,
cost of
make
activities.
it that this interim order will be up to 16th,
Lordship.
up to 16th, not before the, beyond that,
And
not beyond that.
not beyond.
And we
Not
will also
there.
not take any adjournment.
Lordship practically knows what happened
No,
because
practically nothing is happening,
what
nothing
happens
happened.
is.
Practically, the matter will be adjudicated and disposed of,
so
probably in your favor.
Because the.
Because see,
law
Mr.
itself-
Das,
Lordship.
on a hindsight, your contract has been terminated.
Lordship.
Now, even if you are successful,
Lordship.
what will you have? In the meantime, how many days have passed?
2 years. years.
This is a determinable contract. You may be entitled to compensation.
Specifically
For
relief
which,
Act 14
for which we may give you the liberty. You cannot get the contract back and get the work done. You participate here without prejudice to your, okay.
Therefore, stopping
Heard.
the entire contract.
I'm not stopping. Heard 3 M thus. MK.
M thus.
M thus. Why MK thus is
Your
written?
Lordship, MK's name is only shown.
Okay. Heard 3 M thus. Learned counsel for the applicant. Also heard 3 A Sharma, learned standing counsel, IOC. Para. By this interlocutory application, comma, the applicant who is the writ petitioner in the connected WPC 1589 of 2025 has prayed for a suspension of the tender notice dated 17/6/2026 for works of repair and maintenance of buildings and other associated facilities at various zones of Digboi Refinery Township. Full stop.
Page 18, Lordship will kindly see, it is 125 work orders.
What is
So he might get only one work order, not 125 work orders. So by staying this, if Lordship stays the entire 125.
We are not staying.
There will be a difficulty, Lordship.
We are not staying.
Finalizing and also amounting to.
We are not staying. Which is the order you are, the earlier?
Lordship will see-
No, earlier, which one? You kindly specify.
Yes.
What is the subject matter of the writ petition?
Yes, Lordship.
Lordship will find that at page 161.
54.
Which number?
No, 161. Of the writ petition, page 161.
No, which zone?
Lordship, it does not say zone. It said repair and maintenance of building and other associated facilities at various zones of Digboi Refinery. The same word as it is in the writ petition.
Mr. Das, are you interested in all the zones?
My clear instruction, he was one of the selected bidders.
Lordship,
There were
because the work
multiple-
order does not say which zone. here.
Multiple, he knows that, there are multiple. He is not.
Work order is of which zone?
The work order does not say anything about the zone, Lordship.
But my clear instructions is. it is
Mr.
only
Das,
one.
you take instructions. We'll have this on Monday.
Because the
Online.
amount.
Lordship, can it be at 2? Or after some time, I will take a telephonic.
If it is for
instruction.
one zone, we may agree with you. For
Yes,
that zone is concerned,
Yes,
Yes.
we may ask him to participate. For the others, there cannot be any stay.
yes. Because Lordship,
At 2 o'clock.
And at Township, if something
At,
happens, it's difficult.
at 2 o'clock.
Lordship,
But what were you doing for the last 1 year? How has it been maintained?
Lordship, it is only after the
Who?
RTI was filed, they come up with this.
There are other contractors also, not only one. Digboi Township will not be run by only one contractor.
So you give us you can also get the instructions. Which zone the earlier work
So
was
even my learned
allotted
friend
to
can
the
obtain the instructions. I will try to get
At
the
2 o'clock.
instruction also.
at 2 o'clock.
Lordship,
দুটা বলে মাত্র।
obliged.
দুটা তুমি আনি দেবা হ্যাঁ তো।
Tender category is also critical. They say tender category is critical. A lot of issues are there. Someone's team roof may be broken.
That criticality came only after the RTI was filed.
So
If the RTI was not filed, maybe they would not have even noticed it.
for one contractor, we are now going for a new tender process altogether.
No, we'll ensure that the stay order is not against the
Limited only
public
to the
interest.
zone
Public
also.
interest is at large.
Yes, that is why I'm.
Hmm.
Otherwise, I have not placed so much loss.
Okay, next. 2 o'clock. Please come up with specific instruction.
Yes,
The zone which the earlier work order subject matter of the writ petition is connected with.
yes, I'll get that.
15.
May I please, Your Lordship? This related to the contractor's bill payment, Your Lordship. Lordship may find that annexure 1, page number 17.
Similar to item 13, no acknowledgement from the head of the department.
Where is the acknowledgement?
Lordship will find that.
These were the executive engineer.
Lordship, annexure 2, page number 15. That may be Perus work completion certificate, Your Lordship.
That is the work completion. Where is the acknowledgement?
Lordship, on the last line, certified that. Last bottom is certified that the work has been physically verified by me and found 100% complete.
That is the acknowledgement of completion of the work. Where is the acknowledgement of the liability?
Lordship may, there was advocate notice, Your Lordship, against that, Your Lordship, that has been forwarded to the chief engineer, annexure 17, page number 17, Your Lordship. And Lordship may,
This certificate is of which date?
date is at top.
2020.
18/3/2020, Your Lordship.
Okay.
One Tapas Bonikor also approached before this honorable court, Your Lordship, and similar.
See, the Honorable Court has mentioned Tamsir Ali. Tamsir Ali says acknowledgement in writing by the head of the department. What is the acknowledgement in writing? Writing acknowledgement of the dues, not of completion of work.
In this regard, Lordship, it has been.
You
sent
may
to
be
the-
correct in contending
Yes, sir.
that this due is pending, it's not been paid to you. But to read court, we have our limitation. It's not a court on facts.
Lordship, executive engineer sent annexure 4 sent to the chief engineer, Your Lordship, regarding the liabilities, Your Lordship. This is a pursuant to an advocate notice, Your Lordship. My name is figured at serial number 6.
Chief engineer is a party here.
Yes, Lordship.
The chief engineer party, you get the response of the chief engineer. Okay. If he says no, then we'll dismiss it. If he says yes, okay. Heard. What is your name? Ali Chaudhary. Then counsel for the petitioner. Full stop. The instant case has been filed with a claim for contractual dues. Full stop. The learned counsel has drawn the attention of this court to certain communications issued by the executive engineer regarding completion of the works and also forwarding the matter to the chief engineer. Full stop. Do Sri Upadhyay, the learned standing counsel irrigation department, has submitted that there is no acknowledgement in writing of the liability by the chief engineer, which is stipulated by the honorable full bench in the case of Tamsir Ali and others for so and so, so and so. Para? However, considering that the matter was referred to the chief engineer by the executive engineer, mentioning the work as well as the amounts, this court is of the opinion that the response of the chief engineer be placed on record by way of an affidavit. Full stop. Para? Sri Upadhyay, the learned standing counsel, in this regard prays for and is granted 3 weeks' time. Para? We give a date. List on. When? 27th? 27th July. Mr. Ganguly?
This matter, my lord, it's a very simple matter. Otherwise, my lord, the dispute is essentially regarding the payment of bills, my lord. My lord, part payment has already been made. Now, what has happened in short is that, my lord, I as a contractor, my lord, constructed the Assam Police Headquarters building for the ONGC battalion. Now, my contract was with the Assam Police Housing Corporation Limited, my lord, who are the respondents 1 to 3. Now, they had a separate agreement with the ONGC, my lord, for this entire work. I have no privity of contract with ONGC as such. ONGC pays the money to APHCL, APHCL gives it to me. Out of the total claim, which was initially 4 crore 86 lakhs, they have already paid around 2 crore rupees. Now, the affidavits which have been filed by the respondents, they show clearly that the dispute is disagreement.
Have you filed your reply in terms of the last order 5526?
Reply, my lords, to the
Because the court says that pleadings are yet to be complete.
lordship.
In the meantime, respondents are directed to complete their pleadings on or before 5/6. 26.
They are the respondents. They have filed their affidavit.
5/6, 8/6 they have filed.
Lordship.
And you were given time to file your rejoinder by 12/6. Well, are you,
Well, I submit that perhaps no rejoinder may be necessary in this.
then we can have it for admission hearing.
Lordship.
Okay. I will record that rejoinder may not be
May
necessary.
not be necessary because.
Yes, Mr.
Admitted.
Lordship, if you are on behalf of respondent for ONGC, we have MOU between Assam Policing Housing Corporation and ONGC. Now, we have given the more than 12 crores in this project to the ONGC, and last bill we have dispute.
Not to the ONGC, to the Assam Police.
Assam Police.
Okay.
So we have dispute. There is a clause in our MOU regarding the arbitration cost also. It's matter of that is.
No, your dispute will not be with the petitioner.
Dispute is not with the.
Your dispute will be with the Assam Police.
Because
Now,
we have-
he is the one who is the victim here.
Yes.
In terms of not getting the amount for which the work has been done.
We paid more than 12 crore for entire project. Only remaining that is last final bill is pending. And there is a dispute in the final bill. The claim of there is Assam Police Housing Corporation or ONGC, there is a dispute. And in the MU signed between ONGC and Assam Police Housing Corporation, there is a specific clause in clause 9 of
Okay,
the
heard Sri A. Ganguly, learned counsel for the petitioner. Also heard Mr. Bora for Sri D. Bora for respondent numbers 1, 2, and 3, and Sri T. Das for the respondent number 4. Tara? Both Sri Bora and Sri Das, the learned counsel, has submitted that affidavit in opposition has been filed on 8/6/2026. Tara? Sri Ganguly, the learned counsel for the petitioner, has submitted that rejoinder affidavit may not be necessary. Tara? In view of the above, list for admission hearing on 15 July 2026.
All right.
The Assam Veterinary Fishery University is a necessary party here, Lordship. If it takes this instruction.
Assam?
Assam Veterinary Fishery University. Because there's.
Assam veterinary fishery industry?
Yes.
What is this?
Universities.
Assam.
Veterinary fishery.
Assam Veterinary and Fishery University Act.
Because the ZLRS has been transferred to that university.
You take instruction, Mr. Dutta.
No, I've taken instruction first.
We'll have it immediately after the
Madam,
vacation.
because this, all these communications were
Oh.
Assam
Yes,
University, madam, Agriculture University.
Yes.
In fact, the MP order also.
Heard 3M
Nothing
Dutta,
was there, madam.
learned senior counsel for the petitioner. Para 3R Gogoi, learned standing counsel.
Assam Agriculture University.
Assam Agriculture University has, however, placed before this court copy of a communication dated 17/6/2026
That's it.
and has contended
Nine, huh? Change it.
that the Assam Veterinary and Fishery University would be a necessary party. Full stop. Para Sri Datta, the learned senior counsel, prays for some time to obtain necessary instructions. Para when can we have
After the vacation.
matter accordingly stands adjourned to be listed on 14th of July, one more day,
Madam.
immediately after vacation, 14 July.
Madam, the interim order may continue, madam.
Is interim order passed earlier to
On the last date, madam, interim. order.
to continue till the next date of listing.
Can it be on some other, except, madam, beyond 14, madam?
Then 15th,
Madam.
15, 16, whenever is it?
16, madam.
16.
I'm like,
So you come back from vacation on 14th.
yes, madam.
Mr. Chakraborty will appoint you as the amicus. There's a challenge to an award of the labor court where the workman though served has not appeared. So considering it's a labor matter, we think that we'll have your assistance to come to a fair finding, not to defend anyone, but to assist this court. Okay. And Mr. Kyle is also very happy.
Otherwise, he's very fair advocate.
Otherwise, normally not.
I'll
Okay,
provide a copy of the petition to him.
okay, yes. Heard Sri S.C. Kyle, learned senior counsel for the petitioner. Full stop. The challenge in this petition is with regard to an award dated 28/7/2022 passed by the Learned Labour Court, Assam, Gauhati. Full stop. It was not a reference.
Not a.
2A. The said dispute was raised by the workmen under section 2 within bracket capital A within bracket 2 of the Industrial Disputes Act 1947. 48 কি লিখছে 47 48 কি লিখছে 947 ফুটস the para the procedure the materials on record would show that the workman was served in spite of which there is no representation. In spite of which he has not appeared. Full stop. This court, wide order dated 24/4/2026, has also observed that service is complete. Para. Considering the subject matter wherein there is involvement of a workman, comma, this court is of the view that an amicus be appointed to assist this court from the side of the workman. Accordingly, this court appoints Sri Shantanu Chakraborty to act as the amicus in this matter. Para. Let a copy of the writ petition be served upon him by Sri Jain, learned counsel assisting the senior counsel for the petitioner. Para. List on, we'll have it on 15th of July.
Lordship.
Then we can have fix a date for hearing. 15th of July. Para. Raise fee to reflect the, now cause this to reflect the name of Sri, reflect the name of Sri Shantanu Chakraborty as the amicus curiae.
Much of.
May please, your lordship. Lordship, the non-payment of the contextual use, lordship. The chief engineer has a
Executing authority is the PWD. They have not received any proposal from the PWD. Lordship. Work invoking section 50 of disaster management. That has to be placed before the SEC, the State Executive Commission.
Lordship, on our part, we have received certain instructions, Lordship.
What does it say?
The necessary documents as was directed to be furnished by the last order, Lordship. Those documents were provided to the Revenue and Disaster Department. To take action, Lordship. These are the documents.
No, those documents they have already taken cognizance of and have been finds reflection in the order dated 12 June 2026. Now, what do you say, Mr. Datta? Where is Public Works Department? Are there parties here?
Yes, yes, lordship, yes.
Public Works Department. Who appears for
Chief
Public Works
engineer,
Department?
chief engineer filed their affidavit, lordship.
Chief Engineer of which
PW
department? PWD.
Yes, lordship. They have not-
Can you have anyone from PWD? Who appears for PWD? Nayak, Nayak, R. Chaudhary, P. Gogoi, S. Sharma, M. Das. Names are reflected or not? M. Bhuya, yes. PWD names are reflected. So Gogoi, after a while, let them come, we'll have them. It all of piece of parties, huh?
Lordship, in this case, I have filed one petition, Lordship, today, Lordship, for implement as a response number 5, Lordship.
Who are you?
I am the vending partner of the Tifaru group of company where the petitioner is trying to enter into this by way of this petition, Lordship. We have not been made party, Lordship. The entire
Now you want, what is your prayer, Mr. Kothari?
Lordship, our prayer is very limited to the order by the respondent number 4, which has barred us from entering the premises. Now, respondent number 4 is the officer in charge of the entire So our issue, so far as the partnership dispute is
Who is
concerned,
R4?
respondent number 4,
You are there, Mr. Chaudhary? You are for R4. Who are you? What is your name?
Niranjan Ligira, my lord.
You are an individual.
I am an individual. I have been pleaded as an individual. I
By-
was the officer in charge.
How do you approach the writ court? Why?
Lordship, by name, but he is a statutory authority. Relief is sought from the office of
What
the,
office?
officer in charge is a statutory authority of the excise department.
Excise department.
Yes.
Excise department, my lord. I was deputed to look after the Safari Group of Industries, which is a partnership firm. They had a liquor bottling plant there. I was looking after it. There were holograms and everything.
And Mr. Datta, you are whom?
I am that Safari Group of Industries, Lordship. I am the managing
You
partner.
have objections to his?
Yes, Lordship.
Oh. Okay, we'll let your petition be
Lordship.
be listed. Okay, when?
Next week, Lordship.
Next Wednesday?
Lordship.
Are you having serious objections to his implement?
Lordship, otherwise my.
Have you been
plaintiffs-
served?
No, we have not been.
I have served, no, Lordship.
In fact, I was not even aware. I have.
It's a filing, Lordship.
Okay, you'll be served.
Lordship.
If you think that you need time to object or you have serious objection, we can grant you time on the next date. So next date, we'll have it on Wednesday itself.
Lordship may allow. Lordship.
But we have to have that petition.
Lordship.
Wednesday.
Lordship.
Okay. Heard Sri Y. Kothari, learned counsel for the petitioner. Also heard Sri N. Goswami, learned standing counsel, excise department. Whereas Sri N. Chaudhary has appeared for the respondent number 4. Para. Sri P.P. Datta, learned counsel, has submitted that an application has been filed for implement, which however is not listed. Para. In the interest of justice, matter is adjourned to Wednesday, when the same is directed to be listed along with the IA stated to have been filed for implement.
Lordship. Deeply appreciated.
Mr. Gogoi? There is some issue which perhaps can be sorted out. Your public health department is a party. You take instructions. In fact, you had appeared earlier. Your names are shown.
Affidavit, they filed it.
Now there are certain developments after the last order. There are movements from the government to the revenue department, and revenue department has issued a latest instructions to Mr. Datta, 12 June. Last part. Okay. Oh, okay. Heard Sri B.K. Gogoi, learned counsel for the petitioner. Para. Also heard Sri B. Gogoi, learned AAG, Sri Satyajit Datta, learned standing counsel, revenue, and Sri R. Taludar, learned state counsel. Para. In terms of the earlier directions passed by this court, there are certain movements between the departments. Full stop. Sri Datta, the learned standing counsel, revenue department, has placed before this court a communication dated 12/6/2026, which has been issued after examination of the documents received from the office of the district commissioner, Dhemaji. Full stop. The said communication also mentions that the public works department would have a rule. Para. Let copies of the communication be handed over to Sri Gogoi, the learned AG representing the public works department, to enable him to obtain the necessary instructions. Para. List on which one? 17th of July.
Public Lordship.
Give copies.
Yes, I'll give it.
Please, the Lordship, the matter relates to non-payment of contractual dues, Lordship, and on the last occasion, Lordship, they took time to file their affidavit.
Lordship, as per our instruction, they have already received their bills. I
No,
mean,
Lordship.
and their copy to them. If
Uh,
they, in order to have some instruction from their client. Lord.
On the
When did you have the last instructions, madam?
When the matter was last listed on 27th, 27/5 lots.
This-
2/6 lordship, 2/6.
This year?
Yes, lordship, June.
But when, where,
In fact,
your
we have
communication,
certain documents.
your
also, which
communication are of which date?
15th of May 26.
We have talked to our client on 2nd of June, lordship.
Just have a look.
Your bank statements and all have been annexed. Lordship.
Oh. Ask your client to visit their bank.
He has visited lordship. He said he has not received any.
He has to
money.
visit that bank where he has where is the account, not some other bank.
Lordship will file our additional affidavit in this matter then, because he has not received any,
After going through
he
the
has
communication.
not received any money, lordship.
How much amount?
25 lakhs, 24,800.
How have you made the payment, Mr. Talukdar?
And
Ah.
credited in their account.
Then close this,
No,
madam. How can it be so?
Lordship, he has not received any amount, lordship. In fact, he has submitted extra bills.
Person is funded by the district of Mr. Lord.
We cannot keep this pending.
Any date may be given, lordship, then on 26th or on immediately after vacation. 30th.
No, not 26. Your client are from which place?
Tejpur,
Tejpur.
Sonitpur, lordship.
This, everything is there.
We'll file our additional affidavit in that case, lordship.
No, not required to file affidavit. We'll have it on Tuesday next or Wednesday next. You can take instructions.
Okay,
You
lordship.
confront them with these papers. They may not be truthful to you. You confront them with these papers. Heard Miss Yunanda, Learned Counsel for the petitioner. Para? Sri R. Talukdar, Learned State Council has however submitted that the amount in question has been paid to the petitioner. Full stop. In this regard, he has placed before this court written instructions dated 15 May 2026, along with the relevant documents. Full stop. Let though Ms. Nanda, the Learned Counsel, has submitted that no such instructions have been received from her client with regard to payment of the outstanding, this court directs the Learned Counsel to take fresh instructions. Full stop. Let this matter be listed on Wednesday next. You did deliver. Wednesday will be 24. Mr. Talukdar, take this back.
God bless you.
Dispose of the matter as per instruction furnished by the state council here, because the land already handed over to municipality as per instruction.
Who? Circle officer. Then circle officer.
Last
Mr.
applicant, they submitted
The report. Lordship.
submitted report last, already submitted report. As per report that already land already handed over municipality.
So it's been done.
Done.
We can withdraw this.
Dispose of as per instruction.
Where is that report?
Lordship, it is dated 28th of May. 26. I can send over one copy. Lordship.
Just a minute, please. Right. Heard Sri S. Islam Learned Counsel for the petitioner. Also heard Sri R. Talukdar Learned State Council and Miss P. Thapa Learned Counsel appearing on instruction of Sri S. Dr. Learned Standing Council PNRD. Para. The instant writ petition has been filed by 5 numbers of petitioners with the grievance that the Dhubirchar Hat
Dhubirchar.
and Dainik Bazaar was not included in the NIT dated 2/6/2025 issued by the newly elected Panchayat, Falimari Gaon Panchayat, correct? Full stop. It is the case of the petitioners that though they had represented, there was no response. Para? Mr. Talukdar, the learned, Sri Talukdar, the learned State Council has submitted that the issue would arise, would culminate into the aspect of demarcation of land. And in this regard, he has placed before this court written instructions dated 25/2026, as per which the land was redemarcated on 14/5/2026 in presence of the parties. Full stop. A copy of the communication dated 25/2026 is also furnished to Sri Islam, the learned counsel for the petitioner, who submits that in view of the aforesaid development, the petition may be closed. In terms of the aforesaid development, which is reflected in the communication dated 25/2026, the petition stands closed. The said communication dated 25/2026 issued by the circle officer, Dhubri Revenue Circle, is made part of the records.
Obliged.
22.
Regarding this.
Page 13 is the liability statement and amount is admitted, Lordship, and they filed affidavit also.
Okay. Heard Ms. K. Chaudhary, learned counsel for the petitioner, also heard three. Also, also heard three R.M. Das, learned standing counsel, Water Resource Department, Sri Satyajit Datta, learned standing counsel, Revenue Department, and Ms. Udas, learned State Council. The matter pertains to a claim for disbursing contractual dues. Full stop. Ms. Chaudhary, the learned counsel for the petitioner, has drawn the attention of this court to the affidavit in opposition filed by the respondent number 4 on 11/2/2026, in which the liability has been acknowledged. Full stop. Sri Datta, the learned standing counsel, Revenue Department, has also placed before this court written instructions dated 12/6/2026, as per which an amount of rupees 17,72,045 has been approved and been allotted to the Deputy District Commissioner Nagaon. And the process of financial sanction has been initiated, after which sealing proposal would be submitted to the Finance Department for approval and final disbursement. In view of the aforesaid development, this court is of the opinion that there may not be any live cause of action to be adjudicated. Full stop. Accordingly, while this writ petition is closed, the process of disbursement is directed to be, which has been undertaken, is directed to be completed expeditiously and preferably within a period of 3 months from today.
Okay.
Same matter, similar matter, Lordship.
What about here? You have,
Page 15 is the liability statement.
no, what about the letter?
They file affidavit, Lordship, admitted. Water is 9.
That in the earlier case, there was a letter that the amount was sent to the,
Lordship, here the parties are Union of India is there, Lordship, and they have filed.
Regarding
oh, it's a different matter.
Lordship,
Subject matter is the same.
same.
Okay.
Lordship. Parties are different.
And Madam Brian, you are from whom? Okay.
there is some objection regarding payment of this, and we have written to this executive engineer, water resources has written the same to the AG regarding this one, outstanding payment.
But you have filed your affidavit.
No. Yes,
Lordship.
R4 has filed, 129 has also filed.
Lordship.
What have you stated in your affidavit?
Lordship, it's a small amount, Lordship.
No, what have they stated in their affidavits?
Lordship, in our affidavit, paragraph number 8, we have stated that there is an audit objection, because of which the payment could not be released. And to meet up the audit objection, we have already written to the accountant general, office of the accountant general.
Okay. It can be sorted out for which for this can the petitioner be faulted?
Once we get the clearance from the office of the accountant general, we can.
I will grant you some time, okay. Is AG a party, madam?
No.
AG is not a party?
No, Lordship.
Okay. Heard Miss K.K. Chaudhary, learned counsel for the petitioner. Also heard Sri R.M. Das. Also heard Miss A. Garan, learned CGC, Sri R.M. Das, learned standing counsel, Water Resource Department, and Miss U. Das, learned state counsel. State is a party, I think. Sarah? The learned standing counsel, Water Resource Department has informed that though the matter was processed, there is some objections from the office of the accountant general. Full stop. He prays for some time to get up-to-date status regarding the resolution of the resolution of the issue. Matter is accordingly adjourned to be listed on 24th of July. This you can take it back.
Item 26. In the month of March only, we have written to the office of the accountant general. They were sitting over the matter.
Is AG a party, not a party?
Not that part.
You also, next date, we can have the standing counsel and take his views.
Okay. That will be better.
Item number?
26.
J.K. Bhuya. None appears for the petitioner on call, whereas the state is represented by Sri S.R. Barua, the London State Council. In the interest of justice, matter is adjourned to be listed after the summer vacation.
Item 27.
Twenty-seven.
I'm agree for it. That's number 1, 2, and 3.
Who's for the petitioner, Mr. Dutta? Who are you? Who are 1, 2, and 3?
What was the fact?
Bank. And what is the case of cause of action?
Action is that this fraudulent transaction.
Or freezing of account?
Yes.
Yeah, for the petitioner.
No, from the bank. Not
For?
bank. Yes.
Mr. Dutta, you have to come again. Your friend on the other side is not there. Yes, Mr. Are you the counsel?
Item number 27.
27? Yes, where are you? Missing in action. Yes, what is your case?
There was a complaint registered in Java. And some amount has been.
You have a bank account
Yes, Lordship.
in his bank.
Yes.
What is the amount involved in the transaction of fraudulent transaction?
Lordship, 65,000.
65,000. What do you do?
I'm a bank correspondent, Lordship.
You
Bank
are a
correspondent. Bank correspondent, Lordship.
bank correspondent means?
Lordship, petitioner number one, husband is the bank correspondent. She is a housewife, Lordship.
What is a bank correspondent?
Actually, what this in small towns,
Customer service point.
they do this customer service.
Okay, a service provider.
Service provider.
Yes, they have the small outlets.
Yes.
Smaller.
Yes, yes.
They ask the these customers to and come to the bank and
Deposit.
open accounts like that.
Okay.
Now, what has happened in this case that
And from where do they get the honorarium or whatever? The
I think that, so far my knowledge goes, it's about percentage.
percentage.
So
Okay.
far my knowledge.
But that is besides the point. He had an account in the bank.
Yes.
Now there was an illegal transaction of 65,000.
Yes.
Your bank, otherwise, what is your how much is your amount which is deposited?
Something around 49,000.
So how can you get it operated if the 65,000 is the amount involved? Normally,
No,
what
on
we
that-
do.
On that day, Lordship, I have enclosed the bank statement, Lordship, page 17, Lordship.
Mm.
Although there was the amount that is already in the account, Lordship, that was around 20 lakhs, Lordship. It is
You
in
had
my
20
bank-
lakhs.
Yes,
Then
Lordship, that due to that fraudulent transactions, Lordship, my bank account was frozen. Later on, it was defreezed, Lordship. And
what happened to this 20 lakh? That was your amount.
Yes, my amount.
That has been siphoned or what?
Yes, no. Lordship, only the disputed amount is 49,000 something amount.
Rest of the amount?
Rest of the amount, it is there.
It's there.
Yes.
So that is what we're asking. How much is your account is holding as on
Because,
today?
so far, according to their petition, there are two parts. One is 50,000 and one is 49,000. And there are the two FIRs has been lodged in Ghaziabad.
No, we are not on the second one. We are on the first one, Lordship. First complaint, Lordship. Page 24.
No, the freezing of the bank account is in connection with which complaint? 50,000, 49,000,
No, Lordship. Complaint number, Lordship, page 24A.
49,000.
Yes.
How much amount are you holding in the account?
On that day, Lordship,
No, as on today.
as on today, last, the bank statement says that 11 lakhs, around 11 lakhs.
11 lakh.
11 lakhs.
You cannot freeze the entire account.
No, they are operating that.
Only that amount I am claiming, Lordship. 49,000 something, they have kept it in hold, Lordship.
Oh, then that has to be,
Yes.
that has to be adjudicated.
Yes, Lordship. They were liberating.
No, we
us-
thought that it was entirely frozen.
No,
It's
No,
been
not frozen. Not
So
frozen.
normally what we do, we keep the amount and additional some amount as on lien for 6 months and allow to operate because at times for an unscrupulous customer, it can be difficult.
Yes.
Somebody makes a deposit from some cyber crime. You are not even aware. 1,000 rupees deposited, amount of 10 lakhs put on hold.
Yes,
So you file your affidavit.
that's why.
Okay.
Matters, similar matters are fixed on 20 July.
20?
20th July.
20.
20.
Okay. You are P. Mazumdar.
Yes, Lord.
Heard Sri P. Mazumdar, learned counsel for the petitioner. Also heard Sri S. Datta, learned counsel for the respondent bank. Full stop. Sri Datta, the learned counsel prays for and is granted 3 weeks' time to file the affidavit in opposition. He has also submitted that similar matters are fixed on 27/20/26. Para. This matter is accordingly adjourned to be listed on 27/20/26 along with WPC. Please try to have it. Along with put by the next date, comma, the affidavit is required to be filed with respondents.
Obliged.
Until 28.
Item number Okay, কি হলো go to tonight. None appears for the petitioner on call, whereas Miss Udas Learned State Council is present. Para, in the interest of justice, matter is adjourned to be listed after the summer vacation.
May I please, your lordship? Lordship, matter relates to non-payment of outstanding dues, your lordship. The last occasion of direction given the respondent to file affidavit, your lordship.
Give some instruction, lordship. From that, it appears that some amount has been paid. And he is
Yes.
claiming some more amount, lordship. So that document is not available in our directorate list. So they have sent one letter to the petitioner to provide certain documents and reports and all.
Have you got that letter?
No, no, till. Just-
Heard Sri P.K. Medhi, Learned Counsel for the petitioner, who has approached this court for a direction for release of contractual dues. Para, Sri S.R. Barua, Learned State Council. State Council or which State Council?
State Council.
State Council has submitted that upon inquiry, some amount has been found to be due, and for the balance amount
No, no, some amount we have.
Paid.
Paid, yes. So far as our instruction is concerned, no such liability is there.
Okay.
But still we have sent.
Okay, has submitted that no liability, there is no pending amount which is required to be paid as the amount entitled to the petitioner has already been released, full stop. However, the petitioner has been directed to submit any documents justifying his present claim, correct?
Lordship.
Sri Barua, the Learned State Council has in fact handed over a copy of the letter to Sri Medhi, the Learned Counsel for the petitioner. Para, in that view of the matter, comma. In that view, the matter stands adjourned to be listed on the 29th of July, by which time, comma, the petitioner may take necessary steps in accordance with the letter. Dated,
Lordship.
the date of the letter,
Letter 15/6.
15/6/2020. Okay. বললেন। এটা বোধহয় ঘুমের পাবেন। লাস্ট আইটেমটা কিমান নম্বৰ আছিলে?
Tendering process where the total budget amount is around 41 CR. In that, this particular NIT that is before lawsuits in the IA, therein total 125 contractors will be ultimately shortlisted and work orders will be issued. That will
125 zones.
125 it will be split into 125 work orders. Work orders means contractors.
Okay.
Translate to one contractors per work order.
Yes.
So therefore, the value of work that he will ultimately get will be a portion of it. If a lordship would see his earlier contract, which was terminated, his value was 31 lakhs. So what my instruction is, it is basically a shortlisting of contractors for doing that all comprehensive maintenance work for the refinery, for the township, and there are other.
You're empanelling contractors. No, but you are also allotting works.
It is sort of what is happening is we are allotting them a work order for a particular amount.
Correct.
This is the value of work that he will be entrusted to within the next period of 2 years.
Yes.
And that is interchangeable. Presently, in the earlier tender, he was working under the Zone 8.
Zone 8.
Zone 8, that is a particular zone within the township. But then, what my instruction is, it is interchangeable. We have that list of contractors pursuant to the NIT process. For this present NIT, it will be 125 contractors. Per contract, there will be a work order. And then there will be a value assigned to him. That this is the amount of work that he can do. And it can be interchangeable also. So therefore, staying a particular portion, maybe it will be a bit, for the workings of that will be a bit difficult that way. Because today he is in Zone 8. He was earlier in Zone 8. This time, if he participates, if he meets the eligibility, there will be some other zones that he might get. And the issue is, this is about refinery. Digboy refinery is also involved.
No, Mr. Sharma, we are not staying as such. You said that your last date is, what is the last date? 7th.
7th.
Last date, opening of the tender is on 9/7.
Opening.
Opening is on 9/7.
2026. 12 p.m.
Opening. And the courts are reopening when? 13th.
Yes.
13th. 9/7, if it's the opening, you will need time to evaluate the bids, isn't it? Okay.
Lordship can otherwise give a limited.
We'll give.
Not to finalize it so far as the Zone 8 part is concerned.
We'll balance it. Don't worry. We'll balance it. Hard 3M to be
refinery work is stopped. It will be difficult.
Hard 3M ki asla gorkini. Nahi to be. Full stop. It is the contention of the applicant that he has put that as writ petitioner, he has put to challenge the termination order dated 12/7/2023, by which the work which was earlier allotted to him.
Termination is
8/8, Lordship.
Termination
Not 12/7.
No.
What is 12/7?
12/7 is the work order. 12/7/23.
Termination of the work order. Termination of the work order dated 12/7/2023, which was done on 8/8/2024. Full stop. It is submitted that during the pendency of the litigation, the present tender notice has been issued, in which case the petitioner would suffer, the applicant would suffer grave prejudice. Per contra, Sri Sharma, the learned counsel for the IOC, has submitted that in the writ petition, there was no interim order as such.
In fact, there was a prayer made by.
There was no interim order was passed in spite of there being a prayer.
There have been a prayer to stop any further allotment of.
Stop.
Page 38 is there.
Full stop. He has submitted that the present tender pertains to the work of repair and maintenance of buildings and associated facilities, which is of paramount importance.
Digboy refinery, township.
No, we have orders to do.
Refinery also, because refinery work, if it is stopped, it will be difficult.
Paramount importance, which includes works of the Digboy refinery.
Township and other zones are there.
Full stop. He has also submitted that the subject matter of the writ petition would have no direct connection with the present work, as the earlier work was determinable in nature, and the legality and validity would be decided by this court in the writ petition, which cannot.
Critically enforced, as per the Special Relief Act.
Would be decided by, and the same cannot restrain the authorities to issue fresh tenders for the fresh tenders. He has also submitted that upon instructions, he has submitted upon instructions that there would be 125 work orders.
It is there in
It
the
is in
NIT
the-
itself. It is stated.
Work orders, and therefore the aspect of passing an interim order would not arise.
If he is selected, he will get only one work order.
After considering the rival submissions, this court is of the opinion that no case for passing any blanket order, interim order is made out. However, to balance the equities, while this court has not put any restraint on the tender process, so far as Zone A is concerned, eight is concerned, the final allotment order may not be issued till the next returnable date. It is also provided that without prejudice to the rights of the rights of the applicant connected with the writ petition, he may participate in the fresh tender process. Let this matter be listed immediately after the vacations on 15th of July.
For disposal of.
Or this 15th of July, on which date, an attempt would be made to dispose of the entire matter.
Yes,
Not entire matter, to pass final orders in this.
in the writ petition.
Also, one small prayer, Lordship. Lordship has given me the liberty to participate, but for participating, Lordship may just, if your Lordship pleases, may pass a small order that liberty to participate with the credentials which are in challenge in the writ
That is
petition.
what is under challenge.
No,
Yes,
no,
please submit it.
Otherwise, I will not be able to
That
participate.
we cannot say. That will have almost,
Evaluation, the independent process that they will.
that will almost amount to allowing your writ
Let them
petition.
keep my evaluation pending. Let me at least participate. If your Lordship is giving me the liberty to participate.
No, provided you meet the requirements, we
Lordship,
cannot.
because the work order in challenge, I have to give it. The work order, cancellation, of the work order which was done, that will bring my credentials. Lordship, let them evaluate, let them not evaluate, let me participate, let them keep my tender in abeyance for the time being. Till 15th, Lordship.
Let us see, let him participate. We'll
Let him participate.
we'll see on the next day how they treat your tender.
Lordship.
How they treat your bid, we'll see on the next day.
Lordship, because the work order was cancelled. I have to give that work order. Otherwise, I'll not meet the criteria. So, Lordship, let me participate with the credentials of the writ petition. They will keep it in abeyance. They will not pass any order on my.
Even if we
tender.
pass an order, that will be subject to your lordship's adjudication.
We'll see on the next date.
Lordship, obliged.
On 15th.
15.
Obliged.
We dispose of the IA?
Yes, Lord.
The IA stands disposed of.
One observation regarding the other particular
We have
works,
already-
IOCL has a right to issue work orders.
We have only restraint is only there, that too only not to allot. So for age is concerned.
Only for
Other
age.
there is no restraint at all.
Obliged, Lordship.
Item 30.
30.
If this is item 30, my lord, I am here for the petition.
Yes.
My lord, this is non-payment of the bills, my lord, by the district commissioners of the wrong.
Would like to file affidavit, okay. Heard 3A Chamo, learned counsel appearing online for the petition, Apara. 3 SR Barua, the learned state counsel, however, submits that instructions have been received based upon which he would file the affidavit in opposition. Madam, you are for whom? Who's for? NRC. Miss so learned counsel is present for the respondent number 4. List on. We'll have it on 27 July, Mr. Chama.
My lord,
Okay.
as your lordship pleases.
Next.
Item 31.
Yes.
Respondent. We'll pay the amount sometime. Security money was to pay.
Security money is to be returned. Mr. Jain, what is your case?
That's 2020 only, more than almost 6 years back. Thereafter, there's none of them paying, no return.
If you want, you can file affidavit, Mr. Gupta. You file your affidavit, okay. Heard Sri D.K. Jain, learned counsel for the petitioner. Also heard Sri K. Gupta, learned counsel for the
Respondent one.
respondent, not one. One is Assam, state of Assam. Who is one?
Assam Electronic.
1 and 2. Why have you written a state of Assam here? In the file cover, as for the respondents, para. The learned counsel for the respondents prays for, and is granted 3 weeks time to file affidavit in opposition. Para, list on. We give you a date 27th of July.
Okay.
We have received instruction like to file our.
You have received? Okay, same order passed in here. আচ্ছা মোৰ কেছটো হা এটা খালি লিখিবা বিপি বৰা অনলাইন নহয় আৰু for the petitioner এছআৰ বৰা ইনষ্ট্ৰাকচন পাইছিল ডেট কিমান দিছিল আমি 27th এই আইটেম নম্বৰ যোনটো আছিল 30 আইটেম নম্বৰ সেম অৰ্ডাৰ খালি বিপি বৰা ওকে
$33 and $34 together.
I have received instruction on the lordship. This matter become infrastructure.
Infractors?
Because UI has been cancelled by the department.
What has been cancelled?
UI.
What is that? EOI. You have challenged that?
Yes, challenged.
Okay. Heard Sri R. Sharma, learned counsel. For both are connected.
Yes, ma'am.
For the petitioners in these cases by which challenge has been made against an express of interest within bracket EOI dated 11/5/2026 and 16/5/2026, correct?
Yes.
Full stop. This court had issued notice in both the writ petitions on 21/5/2026. Full stop. Para. Ms. M.D. Bora, Learned Standing Counsel, Transport Department has however submitted that written instructions have been received as per which the impugned expression of interest EOI have been cancelled. Cancelled.
Withdrawn on 22/5.
Have been withdrawn on 20. Also heard Sri H. Gupta, learned CGC. CGC para. This court is of the opinion that since the impugned EOIs have been withdrawn, there is no existing cause of action which requires adjudication. Para. Accordingly, the writ petitions, both the writ petitions stands closed. The written instructions dated 30/5/2026 in which 30/26 with which the withdrawal order has been enclosed are made part of the records. Do you have a copy, madam, this? Okay.
Obliged.
Item 69, subdivision.
Instruction, some the documents are to be submitted by the petitioner. That is up to date RC, insurance along with GST, driving license, declaration certificate and all. They are.
Have you intimated him?
Permission I haven't received, but that is not required. And
Do you have the written instructions?
yes, ma'am.
You can give a copy to them. Okay. Okay. No, I can give a copy. Yes. Heard Sri J. I. Barbhia, learned counsel
same, na?
The second to another, third fourth, third fourth.
For the petitioner. Para. Also heard Miss U Das, Learned State Council, who has submitted that written instructions have been received as per which the petitioner is required to furnish certain documents. First of let a copy of the written instructions be handed over.
Already given.
Let be handed over to J.I. Borbia, the Learned Counsel for the petitioner, so as to enable the petitioner to do the needful. Para, list this case on the 29th of July.
Same, second is also same, Malak. I'm handing over a copy.
Same.
But I'm not receiving
Okay.
this.
77.
Forward
Okay.
date, yes.
71 and 72, Lordship, authority has sought some more time.
71
and 72.
Okay. Heard Sri J.I. Borbia, Learned Counsel for the petitioner, Para.
For
On the
J.I.
prayer of Sri S.R. Barua, Learned State Council, matter is adjourned by 4 weeks to enable him to obtain instructions / file affidavit in opposition. Same date we'll give, list on 29 July.
Date then.
Item 35 to 56.
Yes.
Yes, sir. The item 35 to 38, these are contempt, my lord. Thereafter, others are review prepared by the state, my lord. Basically, we are seeking a review of the order dated 21/12/2021, passed in
21/12.
21/12, my lord. 21/12/2021, passed in petition 2771 and other analogous matter, my lord. I am holding the brief of my lord.
You are seeking the review.
Yes, my lord. My lord, kindly have the brief of item number 39.
39 is
It's
Tajuddin.
Tajuddin, my lord.
One 121.
121.
Who is on the other side? 121.
My line.
Mr. Laskar.
My lord will find the order at page 147. And the relevant portion start from page 156. 156.
Yes.
These writ petitions are decided on the basis of an order passed in WPC number 345/2021, Ajanta Roy versus State of Assam. That writ petition is pertains to secondary education, and advertisement pertains to my lord appointment of graduate teacher. And this particular batch of writ petition here, my lord, appointment of LP school teachers, my lord, LP and UP school teachers. So the ground for review, my lord, these petitioners, when the advertisement was published in the year 2018, the upper age limit for general category candidate was 38 years. That my lord will find at page 95.
Hmm.
A candidate must not less than 18 years of age and not more than 38 years of age as on 1st January 2018.
Okay.
So that advertisement was issued on 11th of March 2018. But due to some litigations, my lord, although advertisement was issued on 2018, that was not continued, kept in abeyance, and subsequently, pursuant to the order passed by this honorable court, my lord, a notice was issued in the year 2020 inviting applications, fresh applications pursuant to that advertisement. That notice, my lord, will find at page 132.
Yes.
Here, my lord, in the notice, my lord, it is for information to all concerned that the Director of Elementary Education Assam had published an advertisement so and so for recruitment of so and so post and so on 11/3/2018 and corrigendum on so and so. Subsequently, in compliance with the order of the Honorable Gauhati High Court dated 28/3/2019, passed in so and so, who have passed the teacher's eligibility test and have all other requisite qualifications as per the DE Assam advertisement mentioned are hereby requested to apply online against the so and so number of posts vacant for regular teachers LP UP school through official website DE Assam from the midnight 27/1/2020 till midnight 11/2/2020. The minimum age for applying is 18 years and the upper age limit is 30 years, 38 years for general, 41 years for OBC, and 43 years persons with disability. So, my lord, here again, the age limit was fixed at age 38 years for general category, my lord. Thereafter, my lord, the petitioners, batches of petitions were filed. They are seeking liberty from this honorable court to apply pursuant to that notice, my lord.
Why liberty is required?
Because some of them have crossed the upper age limit, and my lord, the cutoff date was already over, my lord. Last date of application that was over, my lord. In some cases, this honorable court was allowed to apply offline. But in respect of this particular writ petition, my lord, that was declined, my lord. They have filed a review also. That review was also declined, my lord. Thereafter, my lord,
they were not allowed to participate because they had
yes, my lord. That, last date
their
of
prayer was rejected.
Rejected, my lord. And in the meantime, the last date of submission of the application was also over, my lord. So this batch of writ petition finally decided by the order impugned in the review petition, my lord. While deciding this those writ petitions, my lord, the order passed in this WPC 345/2021 was relied upon. But the facts narrated in the writ petition 345/2021 is different from these facts, my lord. In that case, my lord, those persons were acquired the required qualification when the advertisement was issued. But in the present batches of writ petitions, the persons,
yes,
they are not eligible at the time of the advertisement, my lord, date of advertisement. That, my lord, will find paragraph 3 of the order impugned, my lord.
Mr. Khatune, what are the grounds of review? What is the direction passed by us?
That is why, my lord, I'm just want to
Let's see the direction.
To consider their case, my lord.
The petition has been made of interference and so and so. Is accommodated prior to the recruitment process has to be considered, while so and so, as the case said, reference details has to be considered to based upon their position merits. So if they have acquired the qualification of TET
yes,
during the process
Yes, at the initiation of the advertisement.
initiation, because the advertisement was prolonged. It was initial advertisement you had said was in 2018. So paragraph 18 we had said, it is accordingly held that DLED, a qualification acquired by the petition prior to the recruitment process has to be construed to be meeting the eligibility criteria.
That observation is wrong, my lord. That is why review, my lord. That is why, my lord, I would like to.
Why is it wrong?
Because they have not acquired, my lord. In 2018, they have not acquired. That is, I can show from the writ petition, my lord. Though in the writ petition, they have not annexed the TET qualification and DET qualification certificate, but there is a statement, my lord, where it can be seen that, my lord, they have obtained DLED qualification after 2019. And the recruitment process was begun in the year 2018. In fact, paragraph 3, my lord, the last 4 line, my lord.
Page
157. The only discernible reason, as indicated above, is inability to acquire the qualification of TET DLED before a particular date. This is, however, no dispute to the fact that all the petitioners are otherwise equipped with qualification TET DLED prior to the date when the recruitment process had begun.
When did the recruitment process begin?
2018. 11/3/2018.
And did you stipulate a particular date in the initial recruitment process?
No.
Then why was this observation made?
Because, my lord, there are subsequent development, my lord.
No, this observation.
Yes.
That it is the only discernible reason, as indicated above, is inability to acquire the qualification of so-and-so before a particular date. That means you had stipulated a date.
That stipulation was prior to after 2018, my lord. But those notification is not applicable in this present case. That was applicable in the case of in respect of secondary education, my lord. But in respect of primary LP school, those notifications were not applicable. That is why review, my lord. I'd like to. My lord, may kindly come to page 53, my lord. That was the notification relied by the petitioner.
53.
Page 53, my lord. There is an office memorandum giving some relaxation, age relaxation. This is dated 2nd September 2020. This OM is after the advertisement dated 2018 and subsequent notice dated 2020. Subsequent notice was issued in the month of January 2020, and this OM was issued on 2nd of September 2020. So that's why this is not applicable in the present recruitment process. Here, my lord, upper age limit was raising the upper age limit of entry to the state government service of grade 4 post from 38 to 40 years. And here is a stipulation, my lord. That stipulation, my lord, will find at clause 3. There shall be no change in the procedure of recruitment or any relaxation of educational or other qualification of service conditions, such as age of retirement, etc. The relaxation shall be applicable only to those candidates who have attained the necessary educational or other qualification prior to crossing their existing upper age limit of 40 years. So this is the stipulation. Subsequently, by this office memorandum has been brought in, my lord. And this OM has been subsequently
We'll do one thing. We'll have this as fresh matters. We'll need time as well as application of mind. Mr. Mohanto, you are appearing? We'll fix it.
I am appearing for the contemners.
Okay, we'll fix it. We'll fix it on a particular date and as first item on a hearing date. This will require a fresh application of mind. This way
little
to be difficult.
application, but there is no otherwise. I don't find any merit so far.
No, that is what Mr. Khatoniar is trying to establish, that there is
not at
review.
all.
Review, as you know, our role is very limited.
Very
We have to
limited.
make out.
If they have a case, they ought to have gone for appeal. Now, your lordship has categorically held. Kindly see. I will just,
No, Mr. Mohanto, you are absolutely correct. The review powers cannot be equated with the appellate authority's power.
yes,
Appellate court, they can have a ground. Review grounds are very, very limited.
very, very limited.
Unless they make out a case of review, probably will not. But we have to
Executive.
give full opportunity to Mr. Khatonier.
Yes, my lordship, because the
He is
difficulty
trying to
is,
make out two basic distinction that this order of 21/12/21 was based on an earlier order passed in WPC 345 of 21, which he is contending that the facts are totally different. That aspect you have to deal, number one. Number two, he is also finding fault, prima facie fault, with one observation that meeting the criteria before the recruitment process by
Yeah.
obtaining of TET and DL. What is it? Oh. So those two probably, and whether those would come
DLEL.
within the purview of review also, that is one question. And this may not be the purview of review. This may be grounds of appeal
yes.
for which you can prefer an appeal.
And
So your
lordship may
burden is
fix it.
very high.
Yes, yes, madam. I understand.
We have it on a date.
16th July.
Please suggest a date, but we'll have it as first items.
Yes, madam.
16th
You
of
will
July.
be at liberty to mention
Yes.
immediately after a motion. It's a motion day or no motion day after the motion. Before the admissions, we'll take it up. Tell us.
16 or 21st, whatever is convenient for you.
16 is okay for us. 16?
Yes.
16th of July, madam.
July.
It's
Okay.
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 Right.
Heard the learned counsel for the parties. Parties for stop. The matters would require a deliberation. Deliberation full stop para. As agreed to by the learned counsel for the parties. List on 16th of July 2026. The learned counsel are at liberty to make a mention for upgradation of these matters. Okay, Mr. Chamwa?
My lord, I'm in item 40. There is no review pending in my case, ma'am.
Okay, all will be decided together. Okay.
My lord, my lord.
Obliged.
Mr. Khatonier, kindly formulate your points for review.
Yes, madam.
Facts you can narrate. We'll definitely grant you time, but make it easy.
Yes, madam, for review.
Formulate the points of review. On what grounds are you seeking review?
I will request for a copy, scan copy of this petition, which has not been given to us.
Do you have anyone in the court, Mr. Mohanto?
Yes,
I'll provide, madam.
Mr. Khatonier can give you a soft copy also.
Yes, I'll provide, madam.
Yes, yes.
Oh, he's there.
Yes, my junior is there.
Your associate is there in the court. He can
Yes.
collect it.
Obliged.
Apply.
Anybody, huh? 57, who is there? None appears for the petitioner on call, whereas 3R Talukdar, Learned State Council, and Ms. P. Thapa, Learned Council representing the Panchayat and Rural Development Department are present. Para. In the interest of justice, matter is adjourned to be listed after the summer vacation.
May it please, Lordship. Lordship, here 58 and 60 is the same matter, my lord. 59 is different, it may be segregated. So, my lord, I am 59. So, my lord, kindly take up item 60 first.
Yes, contempt matter.
Contempt
Yes.
matter, my lord. And also peruse the.
The order cannot be complied as after the verification of it was found that the work order was not permissible under the MG and regards. So Lordship,
When have you filed the review?
next week or
You have filed.
No.
Lordship,
Preparing, order is of which date?
My lord, first one 27/4, second one.
Of which year, which year?
Order of 21.
21,
20, my lord, order of 2022.
22.
My lord, 2 days.
You prefer an appeal after how many years? Only 4 years.
My lord,
Verification was found at the work order.
What were you doing for all 4 years? If you had a valid point, you should have contested the review, the writ petition. Now, can you come up and say?
my lord, kindly peruse order dated 3/6/26. Item 60, my lord.
Madam will be in difficulty. Who's the counsel? Are there other counsel? Hmm?
My lord, the order 3/6/26 order was if they fail to payment, they held to appear personally. The order 3/6, my lord. Kindly peruse, my lord. I think in item 60. 3/6/26, last order.
It is however made expressly clear that if by the next date of listing, payment is of the order is not released in terms of the direction issued by this court, Respondent 1, 4, and 5 shall remain personally present on the next date without any further order. Where are the respondents?
No.
Will issue a warrant of arrest. Will issue warrant of arrest. You cannot play like this with the court's order.
Then, my lord, another order 27/4 also. My
Who's
lord.
1, 4, and 5?
Commissioner PNRD, my lord.
He'll appear with a warrant of arrest. Madam, are you playing with the court? Did you convey or not? No, no time. Not time. They have to appear in person. Ask them to appear by 4 o'clock. Otherwise, warrant will go. Ask them to appear by 4 o'clock. Otherwise, warrant will go. We don't have any other option. All right, let us issue the warrant. Heard. Who? We do not know. We are not interested in Mr. S. Datta. We are interested in the personal appearance of the contemners. 360 order was passed. What more do you need? Paragraph 7. We are not on the payment aspect. We are on the aspect of the orders to be complied with or personal appearance. Appear in person. You are not even doing anything. Where is an application to review this or pass another order to allow you? Sorry. Who are the commissioners?
My lord, Kirti Jali, my lord. Srimati Kirti Jali.
Heard 3. And the others, same order.
No, my lord. In
item number, you write it.
it is 60, my lord.
Uh,
Matter same, but order.
Heard 3. M.R. Khandakar, learned counsel for the petitioner. Also heard Ms. P. Thapa, learned counsel for the respondent numbers 1, 4, and 5. Sri J. Hendik, learned counsel for the respondent number 2. And Sri K. Bokolial, learned counsel for the respondent number 3. Para. This court wide order dated 3/6/2026 had, as treated after recording the submissions and the background, had made the following, had passed the following directions: 5, 6, and 7, 8, 5, 6, 7, 8. Para. When this matter had come out, has come when today, the learned counsel for the respondent numbers 1, 4, and 5 has submitted that some steps are being taken to review the order of this court passed in the writ proceeding. Order dated 21/9/2022 passed in the writ proceeding. Full stop. Para. This court is, however, perturbed by the conduct of the respondents who, in spite of the clear direction made in paragraph 7 above, has neither complied with the court nor are personally present as directed. Full stop. Para. This court has taken exception to the aforesaid conduct. Full stop. Para. Nonetheless, comma, in the interest of justice, these matters are directed to be listed for consideration again on Monday for the personal appearance of the respondent numbers 1, 4, and 5, failing which, comma, this court would be constrained to pass warrant of arrest against these aforesaid respondents, as they have willfully and deliberately failed to comply with the orders of this court requiring their personal appearance as directed on 3/6/2026. Madam, be ready to face the worst consequence. Yes, next.
So, my lord, it may be listed along with item 58, my lord. 59 is.
58, you write, list along with 341 of 2023.
If I remember, I am paying for respondent for 1, my lord. Respondent of 1 is satisfied, in my case, respondent of 5 is joining.
Okay, we'll consider on Monday. Okay. And last, Premjit Boro.
I'm appearing at 59.
Item number?
59.
59.
We have passed order in 60.
In 60 you are.
60.
60 in item.
Yes, what is this? Premjit Boro?
Item 59 here, my lord. Can you
Yes.
produce the last order? That is 17/3/25, my lord.
Yes.
On the respondent took time to enable the instruction.
Yes, what is your stand?
So what happens is that my lordship has informed me today about the listing of this case. In fact, your lordship, the respondent number 2, your lordship, is no longer holding the post of the principal secretary. So in my capacity as the standing counsel, lordship, upon receipt of this information, I have appeared.
I think you need to implement
Implement the new incumbents.
Okay. Sri N.R. Sharma, learned counsel, who appears for the BTC, has informed that there are change in the incumbents holding the post. Para.
Principal secretary.
Holding the post. Para. Sri, you are A. Boro.
Yes, my lord.
Sri Boro, learned counsel for the petitioner, prays for some time to file appropriate implement application. Para. List after 3 weeks to enable filing of implement application. Para. The matter stands segregated from
I think 50.
WPC. Which one?
I think 50.
From 58. From 2/6/9 to 2023. We give a date list on 20th of July.
20th of July. Deeply obeyed.
61.
Yes, madam.
Your lordship, on the last occasion, notice was issued.
Steps taken.
Yes, your lordship.
When did
I've checked the record. The in fact, new incumbent joined lordship in the
1 to 4.
1.
4 somebody has filed Wakalatnama.
Is there.
There have been change in incumbents. Madam, you need to file implement application. Who has changed?
Lordship, secretary and chief engineer has changed. 1 and 2 has changed.
What is your name, madam?
K. Bhattacharya.
Heard Miss K. Bhattacharya, learned counsel for the petitioner. First of all, also heard Sri A. Chaliha, learned counsel for the respondent number 4. Full stop. Para. Sri N. Upadhyay, learned standing counsel, irrigation department, has however, who is present in the court, has however informed that the incumbents against respondent numbers 2 and 3, incumbents named as respondent numbers 2 and 3 have Have
One and two,
one, that there is a change in the incumbents. Added as respondables 1 and 2, full stop. The learned counsel for the petitioner accordingly pays for and is granted 3 weeks time to file appropriate application for improvement of the current incumbents. Para, list on 22nd of July.
62. This financial sanction is granted in 1 month 2026. As per my verbal instruction, payment has already made.
You take the instructions, it's a contempt petition. None appears for the petitioner on call, whereas Ms. Sri R. Gogoi, learned counsel, is present for the respondents. Full stop. He has submitted that as per verbal instructions, the payment has already been made. Full stop. Para. In the interest of justice, matter is adjourned to give the petitioner another opportunity. Para. List on 28th of July 2026, on which date, comma, this court would, however, pass appropriate orders if the petitioner is not represented. You take instructions also. Next.
64.
Yes, Mr. Sharma.
My lord, though I have filed an affidavit regarding dusty service, my lord, on respondent number 9, my lord, but there are some defect, my lord, that I have rectified today, my lord.
Has it come or not?
No, my lord, it is not on record, my lord. Document number.
You have appeared for 9. 9 has appeared. Good, very good. Will you like to file your affidavit? We'll give you a copy. Okay. Heard Sri R. Sharma, learned counsel for the petitioner, who has submitted that pursuant to the dusty service affected on respondent number 9, an affidavit has also been filed. Para. Also heard Sri B.C. Musahari, learned standing counsel BTC. Full stop. Para, your name? You are on record or not? Have you filed your wakalatnama? You will write your name. Sri A. Ali, learned counsel, has however informed that he, with his associates, have entered appearance for the respondent number 9. Para. He also 9 and accordingly prays for time to file the affidavit in opposition. Gogoi. Sri R. Gogoi, learned standing counsel Forest, is also present. You are also there. No, also no. Sri R. Gogoi, learned counsel for the Forest Department, and Sri R. Talukdar, learned State Council, are also present. Para. The matter accordingly stands adjourned by 4 weeks to enable the respondents to file their affidavit in opposition. Para. We give a date, Mr. Sharma. List on 24 July.
There is an interim order, my lord.
Interim order passed earlier. Stands extended till the next date of listing.
Can I, my lord, serve copy today?
Yes, yes. তার উপর লিখিবা উপর যে লিখিবা, so Ali has appeared and prays for a copy, an extra copy, a copy of the petition is served on Sri Ali by the learned counsel for the petitioner in the court itself.
Interim order, my lord.
Last week we said interim order. Yes, we have said.